Yes, please.
Weekly list, old matter, item number 1.
My lord, this matter is, it is covered by the circular and similar order has been passed. Recently, similar order is passed to some other people.
Petition is disposed of in same order. Yeah. 30 years. Pending for 30 years.
Old matter. Old matter, item number 2.
Your Lordship, so far as the item number 2 is concerned,
Defects not removed, sir.
the sub item, Your Lordship, the sub item number 1, Your Lordship, that is 1314 days delay.
All right.
So, Your
The
Lordship,
delay being not explained adequately. The delay is not condoned. The petition is dismissed.
and Your Lordship, so far as the
other matters, not the other 3 matters are appearing virtually my notes. That
Yes.
are withdrawn to file appeals. Other
All right. You want to withdraw to file appeals?
Yes, ma'am. Not sir, challenged orders of assessment.
Sir, but you could have done that long ago. Now you want to withdraw and go after 20 years.
Not what has happened earlier is there was a direction by the tribunal to pass an assessment order. The assessment order was not passed in pursuance to the directions of the tribunal. So I came up before your lordships in a writ petition. And that's the reason why this writ petition was kept pending here.
All right. Counsel, the petitioner seeks leave to withdraw these petitions with liberty to file an appeal in accordance with law. If such appeals are filed not later than 5th September 2022, accompanied by applications for condonation of delay, citing the pendency of the present petitions. As reasons for the delay, it will be considered in accordance with law by the appellate authority.
Not the original assessment order to be returned with
Yeah, the original assessment order be returned subject to being substituted with a attested photocopy thereof. The petitions are disposed of as withdrawn with liberty in the aforementioned terms.
Old matter, item number 3.
Your Lordship, item number 3, the involvement, the effect is 55,747.
All right. In view of the
However,
significant
the
tax
tribunal-
effect, the question of law is left open and the petition is disposed of.
But it's my opinions may be not.
Item number 4.
Item number 4, I am appearing in the first sub-item. There's no instructions, my lord. 119 of 201. The first.
No, 144 is the first item.
Your Lordship, Your Lordship may kindly turn to the page 7 of the revision petition. The question of law, whether in the fact and in the circumstances of the case, the Law and Sales Tax Tribunal is correct in law to annul the assessment for the year 7980 on the ground that Sales Tax Officer Intelligence Wing Cuttack had no jurisdiction to assess the dealer assessee under section 12 of the Orissa Sales Tax Act 1947.
So all these questions can be left open. We don't have to decide it after 20 years. In the last 20 years, there has been nothing significant happening in the present case. Even notice is not issued to the other side. Consequently, leaving the questions ought to be urged open for decision, some other appropriate case, the petition is disposed.
Second item, 119 of 201. No instructions.
All right, no instructions disposed of. Both 144, 143, same
Yes.
order.
Weekly list, item number 5.
None appears disposed not possible.
Item number 4 has come. Item, Your Lordship.
Weekly list, item number 6.
Your Lordship, item number 6, 3,980.
Not placed. All right, not placed, disposed.
Weekly list, item number 7.
Item number 7 also 6,825.
Tax effect, is it?
Your Lordship.
In view of the insignificant tax effect.
Item number 8.
Your Lordship, item number 8, Your Lordship. The question of law is at page 10. within the fact and in the circumstance of the case, the finding of the majority view that transaction effected by the assessee under direct billing system does not attract tax liability under Orissa Sales Tax Act is correct.
Again, same thing, sir. No notice also not issued. You say nothing significant has happened in the present petition for the last 20 years. Even notice has not been issued. Leaving the question of law open, the petition is disposed.
Weekly list item number 9.
Here, let's see, item number 9 is very important matter. Here, let's see whether on the facts and circumstances of the case, the sales tax was right and bleached and sterilized gauze and bandage are the same commodity as handloom and powerloom woven cloth and hence tax free.
It's all right. All these questions can be left open for decision of appropriate case. Nothing significant has happened in these petitions. For the last 20 years, notice has not even formally been issued. Consequently, leaving the question of law open, the petition is disposed of.
Weekly list item number 10.
None appears to
After the department.
Weekly list item number 11.
Item 11, my lord, the department has come up before your lordship, challenging, my lord, the order passed by the commissioner appeal, wherein the commissioner appeal has
The opposite party has not even been served. This
My lord.
unit always is locked, it says.
lordship may keep it open, my lord, the question.
Yeah, leaving the question of law open. You say the respondent has not even been served in all these 20
My
years. Leaving the question of law open, the petition is disposed of. Same for 12 also.
12 also same remand
Correct.
order has been challenged. my lord.
Correct.
Weekly list item 13.
13 your lordship against department. Your lordship that meter same meter range.
Same.
Weekly list item number 14.
Same order, 13S. All right.
This is Katak Club, a very ancient club. Is the petitioner of your lordship. In fact, after filing the writ application, there are certain development which I want to incorporate by filing an affidavit. But still then because of 2003, by an innocuous order, this can be also disposed of.
Huh.
I, my lord, your lordship, kindly look to the 4, 5 and 6, the impugned order. And that has been passed pursuant a judgment in a public interest litigation. So far the Katak Club is concerned, in fact, Katak Club had not filed any counter, notice had not been issued, that's a different question. But a review application was filed, and in that review application, it has been decided in favor of the petitioner's club. But the question is with regard to that unauthorized construction, which is denied by the club, now that is 4, 5 and 6. 4 is the
Proclamation notice.
Proclamation notice. 5 is also a letter for demolition of the construction, and 6 also in the similar nature. Now, your lordship, why I make my submission, if your lordship can dispose of this matter, let's turn to page 55, Annex 7.
Sir,
And
no interim order, nothing has been passed.
No, nothing has been passed. That is, yes. Your lordship, come to page 55. In fact, way back in 2015, that is on 22nd March 2015.
1915, sir.
1915.
1915. In exercise of a power conferred by subsection 3 of section 3 of the Ancient Monument Preservation Act, read with section 8, certain ancient monuments of Baravati forts and that particular area has been exempted by the central government. Now, I have prepared a lot, so kindly look to that, the history of the statutory provision. So far, the 2 acts, 2004 Act.
No, all these 3 are protected monuments under this notification.
Yes, sir.
Page 55.
By virtue of that notification, those categories of monuments have been preserved.
So now there is a new statute.
Sir, now a new statute has come in
So if
1950.
any cause of action survives, you file a fresh petition.
Sir, now what we have done, the Katak Club has already moved an application before the state government under that new act.
So you pursue that.
That's right. You also may only say, or will also permit us to make a representation to the
Or-
state authority.
Or
Let the
Mr.
state
Ravindra,
authority
Learned
look at
Senior
this.
Counsel points out that
I think all my friends like it.
under the new statute,
Under
the
the AMSAR Act
petitioner has already made a
1958.
representation.
AMSAR Act 1958.
Right.
Yes.
Under the amendments, the
Orissa-
recent amendments to the AMSAR Act 1958, the situation has changed. And therefore,
And there is another act, Orissa Ancient Monuments Preservation Act 1956. That is a very,
Yeah.
that is,
as well as the Orissa Ancient Monuments Preservation Act 1956, the
Yes.
petitioner has made a representation to the state government.
yes.
He seeks therefore leave to withdraw the present petition with liberty to pursue the aforementioned representation to the
Hello.
state government
Perhaps they will file the representation.
Yeah, will make.
They will file.
You undertake to make
Propose to file- the
representation.
petitioner proposes to file a representation.
And in fact, we have both, but your Lordship permit us because that may not be available before the state government.
No,
File a
there is-
fresh one.
Okay.
We don't know.
Yes, fresh one. That will be.
All right.
That will be.
The petition is disposed of as withdrawn with liberty as paid for. All right.
Can you
Equally,
also add one thing? If such a representation is made, it's state government is liberty to take a decision on this.
Obviously, sir. Obviously.
no, that should not be any time limit.
So not in time without. He's also a member of our club.
No, no, no. I think there should not be any time limit.
Not only he, the advocate general also.
Okay. Item
quickly,
15.
item number 15.
Item 15, my lord, we're challenging the order passed by the appellate tribunal, my lord. But although, my lord, notice has not been issued, the
Yes,
case of
yes.
2003. Lordship, I keep the question of law.
Yeah. In the last nearly 2 decades,
Madam.
not even a notice has been issued to the opposite side. Leaving the questions of law open for decision, some other appropriate case, the petition is disposed of.
Quickly, item 16.
None appears to.
16, I am for the department.
No, I'm hearing of the,
Yes, Mr. Mark.
here in this case, your lordship, when you look at the commissioner's order, the tribunal's order, the authorities clubbed 3 companies together for their clearances and for their taxes, excise taxes. And therefore 1988, 89, 89, 90, 1991 up to a particular date, 2.5 years. The notice was given in 91, not within the period of 6 months, but within the period of 5 years. But there is no finding, as had been held in the case of McBurn, in the case of Kimpahar. Your lordship is familiar with that judgment, 1989 2 SCC 127.
This is only a remand order, sir.
No, it's the remand order I'm saying because they have given me the relief. There is no reason to remand it. And it is a time-barred case where they have said that I have got good case for time-barred. The tribunal doesn't decide it. Because in order to come under the old section 11A2, provided where any duty of excise has not been levied or paid, or has been short levied or short paid, or erroneously refunded by reason of fraud, collusion, or any willful misstatement, or suppression of fact or contravention of any of the provisions act or the rules made thereunder, with an intent to evade. This finding in the show-cause notice is not there, and therefore, by virtue of this judgment, because after that in 2011 they have amended them. And secondly, my lords, once you hold that the clubbing is wrong, and therefore you send back for computation, and as per the separate club, the separate returns and notices doesn't arise. Because the case was because of several factors which took them made them club together. Now there is a deputy commissioner's order that clubbing is not possible. There is circular that clubbing will not be possible. And you also hold that the clubbing is not there. So once clubbing is not there, you have also you to page 40. One minute, sir. Tribunal says just take a minute.
Page 50. Page 50, para 1. There is no find, para 1, last 4 lines. There is no finding whether this erratic payment is not totaling up to 4% of the total cost or share. We have a strong case in favor of the appellant on the ground of limitation as regards the clubbing clearances. Now, if clubbing clearances are already time barred, the tribunal should have decided the matter. And there is no finding that I come under 11A2.
All right. What do you say?
My lord, Lordship, kindly see the impugned order, page 50, my lord.
Yes.
It is only an order of remand.
No. Why he's asking if all these findings are in his favor? Why should he remand it?
My lord, Lordship,
It
kindly see
seems to be
the
already a stale matter. See, you've clubbed many units together.
9 years
Tribunal
in the
categorically holds there can't be clubbing.
9 years in the assessment.
Correct.
From 2003, I am before your lordship.
Yes.
the question of imposition of penalty and other confiscation is also has been kept open, my lord.
No,
But the-
why? Why send it back? If it's
Yes.
a time barred stale matter, why should
Under
it
the
be
case
sent
of
back?
2003, already 19
Yeah,
years
yeah.
have passed, my lord.
That's right. And this is already stayed with this court.
And,
My lord.
and they took 9 years to complete the assessment.
You see, the present reference case under the Central Excise Act 1944 arises from an order dated 9 January 2003. Sorry, arises from an order dated 11th December 2002 of the Customs Excise Gold Bracket Control Appellate Tribunal, Calcutta, bracket CGAT, disposing of the 3 appeals, of which the present petitioner's appeal was one against the order dated 20th July 2001 of the Commissioner of Central Excise, Bhubaneswar, and remanding the matter to the Commissioner for a fresh decision in light of the impugned order of the SIGAT. Paragraph. Before the SIGAT, one of the issues raised by the present petitioner was that the case itself was, the show cause notice was sent to the units on the basis that they were under a common command and control of Sri Indramani Sahu and family members, and that they had suppressed their actual production and made clearances of goods, evading payment of excise duty. The year in question, the period in question was 1988-90 to 90-91. It appears that on the above basis, the production figures of all the units were clubbed together and they were treated as one combined concern. Although there was enough material to show that they had operated independently. Full stop. The second issue was regarding limitation. Full stop. Paragraph. In the impugned order, after discussing the instructions and orders issued by the Ministry of Law, Justice and Company Affairs, as well as the trade notices issued, the SIGAT concluded as under, as regards the issue of clubbing. Take from page 49, the paragraph begins in this view and cannot be upheld. Paragraph. Even as regards limitation, the finding was in favor of the petitioner in the following terms, bottom of page 49 and first paragraph of 50 paragraph. If indeed on both issues, that is the issue of clubbing as well as on limitation, the finding was in fact in favor of the petitioner, there was no occasion for the tribunal, for the SIGAT, to remit the matter to the commissioner for a fresh adjudication. Open petition for redetermining clandestine clearance, if any, unquote. Once it is held that the entire exercise was barred by limitation in terms of section 11 capital A, bracket. So what's the provision?
In that empire they have quoted, I read it. When the duty of excise has not been made.
No, give me the provision number, sir. 11 capital A bracket.
There's no bracket. That's a provision.
Okay, the proviso to section 11 capital A of the CE Act. It was needless for the SIGAT to have remanded the matter for a fresh adjudication. Consequently, the impugned order of the SIGAT, to the extent that it remands the matter for a fresh adjudication, is hereby set aside. The petition is disposed of.
Weekly list item number 17.
17, my lord. Here the department has challenged the impugned order, my lord. Here comes under the monetary limit, my lord. What should be disposed of?
Since the monetary limit, since the tax effect is below the monetary limit, the petition is disposed of in terms of the circular dated.
My lord, I'll give a copy, my lord.
All right.
Weekly list item number 18.
Well, item 18, the decision of the Honorable Supreme Court, basing upon which the impugned order has been passed, has been declared as a bad law in giving the judgments. At page 51, they have relied upon a judgment of JK Udaipur Limited that has been declared in paragraph 24 and 25. Last page. Paragraph 24 and 25. The scheme of Modbhat and Sanbhat credit are not therefore different, and we are unable to agree with the conclusion of the court in JK so and so, that the decision of the JP Revan so and so would have no application to the Sanbhat rules. In our opinion, the doubt expressed by the referring bench about the correctness of the decision in so and so was well founded, having regard to the fact that the Sanbhat rules on different is in defect substituted the Modbhat rules. The decision JP Reva Summit would will continue to apply. The decision in so and so, holding to the contrary, is in our opinion is not good law.
All right. You say it is pointed out by Mr. Sarangi, Senate Counsel appearing for the petitioner, that the impugned order of the Customs, Excise and Service Tax Appellate Tribunal, bracket SISTAT, Eastern Bench, Kolkata, dated 1st June 2005, was proceeded on the basis of the correctness of the judgment of the Supreme Court of India in CCE versus JK Udaipur Udyog Limited, 2004 7 SCC 344, which had in turn held that the earlier decision in JP Reva Cement versus CCE 2001 8 SCC 586 did not apply to the Senvat rules. Stop. Paragraph. By a subsequent judgment in Vikram Cement versus Commercial Central Excise Indore, bracket 2006 2 SCC 351, a larger bench of 3 judges of the Supreme Court of India has overruled the decision in CCA versus JK Udaipur Udyog Limited, Supra. Paragraph. On the short point, the impugned order of the SISTAT is hereby set aside. The petition is disposed of.
Weekly list item 19.
I'm for the department.
Yes.
That notification Lordship was asking, my lord, that is 22/8/2019, Ministry of Finance notification.
Notification dated is 22/8/2019.
No, that is.
Item number 19.
19, no instruction.
No instructions. Post of.
Weekly list item 20.
20 is yours, sir. No.
No.
I'm sorry, madam.
20.
Item number 20.
20 is not, my lord.
Okay. Nana pays dismissal not possible.
Weekly list item 21.
Again, Nana pays dismissal not possible.
Weekly list item 22.
22 is yours.
Made previous lordship.
Yes.
On 14th of December 2007, lordships framed the questions of law as mentioned, as has been framed
1, 2, 3, and 4.
1, 2, 3, 4. So far as question number 1, if it will be answered manners, other questions will become totally redundant. And the question number 1 is covered by judgment of this honorable court, that I estimation. And your lordship, following that order, judgment, have also rendered that I estimation. I'll only take. See the judgment in 51 STC, page 355, and subsequently my lords have decided it on 4/5/2022. I'm giving both the orders. I'll only take your lordships. Lordship may see that judgment. There was no I estimation, there was no physical movement, is undisputed. And I invite your lordship's kind attention to page 44 of the adjudication order. Page 44, my lords, of the brief. Sorry, page 43, my lords. Page 43. As regards the excess, the 480.845 metric tons of iron, iron and steel products found to be excess during the stock taking. I find that the officers involved in the stock taking have not adopted a systematic procedure for taking the stock, full stop. There are no payment slips. To that extent, I accept the contention that the stock taking was not done in physical payment. Thereafter, the first appellate authority at page 70, your lordship also has agreed with the finding of the adjudicating authority. That is in the middle portion. Similarly, I agree with the appellant's contention that excess stock as alleged was ascertained by I estimation. And thereafter, my lords, the tribunal, while saying that the cross-examination should have been done in the second para, so far as the second allegation is concerned, he said that the department has discharged the owners, but the assessee is at fault. That is page 75, my lords. And that is now, so far as I estimation, no tax can be levied on I estimation, is squarely covered by
All right.
51.
All right. While issuing notice the present reference petition on 14 December 2007, the following questions were framed for consideration. Take from page 8, paragraph. The fact that in the present case, there was no actual physical weighment of the stocks, is apparent from the order dated 16th September 1997, passed by the Deputy Commissioner of Central Excise and Customs while adjudicating the show cause notice in the following terms. Take from bottom of page 43 as regards. Paragraph. When the matter went in appeal, the Commissioner of Central Excise Appeals also concurred with the above finding that there was no actual physical abatement of the stocks. Full stop. The tribunal too, in its order dated 22nd March 2007, acknowledged this. Full stop. In other words, the excess stock, open quotation, as alleged, was ascertained by eye estimation on the basis of declarations given by the appellant's own supervisor. Full stop, unquote. Paragraph. That this form of an eye estimation is not acceptable in law for determining liability is settled in the decision of this court in Hari Bhagat Agarwala vs. State of Orissa, 1982-51 STC 355, which has been followed in State of Orissa vs. Habib Rahmatullah and Company, 51 STC 403 Orissa, and also noticed by this court in its order dated 4th May 2022 in STREV number 230 of 2008, bracket State of Orissa versus Messrs. Council for Products. Paragraph. In that view of the matter, the question number 1 framed by this court is answered in favor of the SSC and against the department. Paragraph. In view of the answer to question number 1, the other questions are not required to be answered. The impugned order of the Sistat and the corresponding orders of the appellate authority and the adjudicating authority are hereby set aside. The petition is
take
disposed.
one liberty, my lords, with a lordship's kind permission. Item 60, I have not raised, my lords, for this week.
1660,
my lords.
okay.
60.
This post office is not pressed. All right.
Obliged.
Right.
Vehicle list item 23.
Wait, please, my lords.
Yes.
Because this appeal, my lords, arises out of a revision order, which my lords will find at page 29. Your lordships, the facts of this case are on 14th December 2006, my lords. There was a survey operation whereby my premises were inspected at 6 p.m. That is in the evening after the sunset, my lords. The books of accounts, there was a notice issued to me, my lords, at page 40, your lordship may kindly have. Annexure 4, my lords. Lordships has may I proceed, my lords?
Yes, yes.
Page 40. Page 40, my lords.
Yes.
Take note that silver bullions with impurities weighing such and silver ornaments weighing such and such were detected in your possession at the first floor of this house, taken on rent by you, which were neither accounted for by you nor supported by requisite documents. However, you are given another opportunity to produce the relevant books of accounts and documents within 5 hours in support of the goods held by you, failing which action will be initiated for seizure of goods in accordance with the provisions. Now, my lords, thereafter, my lords, your lordship may kindly have the seizure list at page 41. The seizure list, my lords, reflects only the silver ornaments and bullions, doesn't reflect the documents. Now, my lords, your lordship may kindly have page 48, my statement that is recorded by the STO, the sales tax officer.
But that you have not given the document. Even
Yeah.
the opportunity given.
Sorry, my
you have
lords.
not supplied any document.
Sorry, my lords.
Here, document you're saying without document, but you have not given the document.
Yes, that is what I'm showing, my lords. Page 48. Your lordship, in the middle, towards the my lords, towards the bottom, my lords, this is my statement, my lords. As I'm unable to explain the transactions recording therein, I handed over the same for further verification as detailed below. 4 numbers of diaries plus 1 diary, that is 5 numbers. 2 numbers of order books, 2 numbers of bill books, 109 numbers of handwritten slips. Your Lordship will see the next page. At the bottom, the statement has been recorded by me, read over, explained, admitted to be true and correct. Signed, STO Vigilance. Those documents, my lords, my humble submission, were submitted. And not just submitted, they were taken by the officer. My lords, without, then I asked them, please provide us the documents on the basis of which you can go ahead with your penalty proceedings, where without perusing those documents, I will not be able to comply with your penalty proceedings. Now, my lords, we'll see page 50. It's a handwritten letter, my lords, given by the council on the spot, my lords, with court fees, lordship. May I please read, my lords?
Yes.
In matter of issuance of certified copies in the seized paper, certifies copy of the seized paper seized in course of the proceeding under section such and such. Sir, on 14/9/2006, a survey proceeding was made by your good office and huge papers with silver ornaments and bullions of such and such were seized. Subsequently, the proceeding, subsequent to the proceeding, IT department has also made another survey operation at his native place, Hupari, Yashwantnagar, Maharashtra. In such situations, petitioner dealer is unable to comply or notice without going through the seized papers. It is therefore requested to release the seized papers or to issue certified copies of the seized papers at the earliest, fixing a suitable date.
Now, do you still have these papers with you, or after 20 years?
All the papers, all the ornaments, everything has been released, Your Lordship.
No. He's asking for papers. He says without
those papers have been released.
What is that to show that?
Your Lordship.
What is that to show the papers were released back to him?
Your Lordship, because pursuant to the Honorable High Court's order, before to the revision petition, the revision filed before the Commissioner, he has approached this Honorable Court against that seizure. And this Honorable Court has directed.
Permitted to go back in revision. This court permitted him to file a revision petition. No. The question is, in order to answer the penalty proceedings, he's writing to you saying, show me the papers that you seized from me. What is there to show that you have released back the papers to him? You are now arguing that all the papers have already been released to him. What is that to show that?
That's order number 8 in this petition, my lords, will reveal the real fact. Your Lordship may see the order number 8 in this petition.
Your Lordship. Pursuant to the direction of this Honorable Court, the copies have been released, Your Lordship.
Where do you get it, sir?
See, that I have to take instruction only the order.
No, you can't simply say that. Not
the order of this Honorable Court. This Honorable Court has directed.
When, by which date?
Your Lordship, that order dated.
Same thing, order number 8.
Order number 8.
But you've not complied with that order. 11 May 2007. Otherwise, why would you still keep this petition on?
In this petition, this order has been passed by.
Correct. But have you complied with that order?
Not complied. You have complied, I'm sure. No.
Your Lordship, I'll take instruction with.
No.
Your Lordship, if not complied, Your Lordship, all the ornaments have been.
Anyway, sir, for him to answer the penalty proceedings, he wanted these documents. By this time, the penalty order had already been passed.
What happened here? He admittedly he is an honest dealer. Under section 72, Your Lordship, for a moment, kindly turn to section 72 of the Orissa Value-Added Tax Act. Section 72 and 73, Your Lordship. Section 72 clearly says survey of honest dealer. Your Lordship, as per section 72, a survey has been initiated, a survey proceeding has been initiated, Your Lordship. So pursuant to that survey, 73 proceeding has been initiated, there was a search has been made. And as per section 73(8), Your Lordship, the officer 73(8), your lordship, for a moment. The officer authorized by the commissioner under subsection 3 may seize any goods liable to tax which are found in the possession of the dealer and in the possession of any person on behalf of such dealer and which are not accounted for in these accounts, register or document maintained in course of his business, and a list of goods so seized in the. And accordingly, 73(10) penalty has been issued and notices have been issued and everything has been. And admittedly, he is an honest dealer.
You are not answering the question, sir. He is asking a very simple question. He says you have passed a penalty order without giving me access to my own documents. The order passed by this court clearly shows that till this court passed the order, he had not been given the documents. Otherwise, why would we say, go, please give him the documents?
Since this honorable court has passed the order, I think that authorized officer must have issued. Your lordship, I may be
no. The short ground is this. The penalty order was passed on 29 December 2006.
Your lordship.
Our order is passed on 13/2/2007, 11th May 2007.
Your lordship.
We are asking you by the 11th May 2007 order to hand over documents to him, which means this does not require Sherlock Holmes, which means the 29 December order was passed 29 December 2006 without giving him the documents.
Your lordship.
What is there to take instructions in this?
Your lordship. Your lordship may kindly set aside remand the matter.
Where is the question of remand, sir?
Your lordship, because it is admitted.
We don't even know if he's got the documents or not.
Your lordship, everything is admitted, your lordship.
What is that?
He's admittedly an honest dealer. He's admittedly honest dealer. It is admittedly that he is doing business without any registration, without making payment of any tax, your lordship. Everything has been admitted and it is in the search, everything has been found.
Doesn't give you the right to not to return.
Your lordship, this should have been. Your lordship,
the short ground at which the SSC has challenged the penalty order dated 29 December 2006, which has been upheld by the order dated 5th April 2007 of the Commissioner of Commercial Taxes, Orissa, in the revision case number SU-256/06-07 and SU-257/06-07, is that prior to passing such penalty order, the petitioner was not provided with the documents that were seized from the petitioner's premises at the time of a search and seizure operation. Paragraph. During the pendency of the present petition on 11th May 2007, this court had passed the following order in this case number 6 of 2007. Reproduce the whole order. No, 1 minute. In this case, 8 of 2007, reproduce the whole order. Order number 8. Paragraph. While Mr. Sunil Mishra, learned additional standing counsel, says that he needs time for instructions on whether the above order has been complied with, Mr. S.K. Acharya, learned counsel for the petitioner, states that till date the documents have not been handed over. Is that right, Mr. Acharya?
Yes, Manoj.
All right. Paragraph. In any event, the fact that the above order takes note of the fact that the documents are still with the department and not with the SSC is itself sufficient for the court to invalidate the order dated 29 December 2006, imposing penalty on the petitioner, since that obviously was passed without giving the petitioner access to documents seized from it. Full stop. The request made by the petitioner in that regard was not unreasonable, and the authority ought to have acceded to it before passing the penalty order. Paragraph. On this short ground, the impugn order dated 29 December 2006 of the commissioner, of the sales tax officer, Vigilance, Berhampur, Division Berhampur, and the corresponding order dated 5th April 2007 of the Commissioner of Commercial Taxes, dismissing the petitioner's revision petition against the said order, are hereby set aside. A direction is issued that if not already provided to the petitioner, the documents seized from it will be provided to the petitioner in terms of the order already passed by this court on 11 May 2007. within a period of 4 weeks from today, and in any event not later than 1st September 2022. The matter will then proceed before the Commissioner in accordance with law on the issue of penalty. And a fresh order will be passed in that regard within a further period of 8 weeks thereafter.
Obliged.
Great. All right. The petition is disposed of. The appeal is disposed of.
Grateful. We kill list item 24.
And you have to send your job correction. They don't send it to me.
24.
So may I please, my lords. So in this case, two questions will emerges for your lordship's consideration. This OTC case, my lords. My lords may kindly see, lords, page 18. Whether in the facts and circumstances of the case, disallowance of setup of entry tax paid amounting to rupees 9,54,611 by the taxing authorities under Rule 19(5) of the OET rules, read with Section 26 of the OET Act is lawful and valid. Question number 2. Whether, in view of judgment rendered by this honorable court in the case of Mrs. Ramkishan Rajkumar versus Assessing Officer, Cuttack 1 West Circle, Cuttack 113-450, order of assessment and consequential order without statutory notice under Section 7(4) of the OET Act are lawful and proper. Both the questions are more or less answered by your lordship. So, what has happened? This 19(5), before I take your lordship's attention to judgment of this honorable court, it provides for set of villas. I am a manufacturer of various steel items like angle, joist, rod, all that. For the purpose of manufacturing, I purchase raw material which are basically sourced from RSP, Rourkela Steel Plant. While purchasing, I pay their sales tax, which is a first point levy there. And in addition to that also, Section 26(1) mandates that the manufacturer shall collect entry tax. Pursuant to that obligation, I pay entry tax as well as sales tax to the seller. Here, there are three kinds of procurements that has been dealt in that judgment. One is directly sourcing from RSP. There is no difficulty because they collect sales tax, entry tax. They reflect mention in the invoice itself, and it is telltale.
We dealt with only the other day.
Sorry,
these two separate streams. That is, you directly source it, or you source it from a person who has already paid.
Correct, absolutely correct.
We dealt with that case just the other week.
I have given that. Honorable Justice Javeri and Justice K.R. Mahapatra, in my case, and in the case of this petition on Willers, you will also kindly see the judgment I have annexed.
No, I have followed it, I think, in some other judgment just now, last week or 10 days ago.
My God. It's a reported judgment, Willers. 65 GSTR 373, Orissa, 2019. Page 373. I have given a copy to Lordship. Your Lordship will find this honorable court has reproduced all the bills also. But how this is channelized? Supposing in the case here also same thing, same party, same. Alpha Steel, my seller, he has procured steel from Rourkela Steel Plant, and I have purchased from Alpha Steel. Alpha Steel certifies that tax is paid on the body of the invoice. That is what the requirement of Rule 95 provision per setup. I have claimed setup. That is not allowed below. So your lordship said that if it is paid, only recourse is to verification. In that case, your lordship laying down all the principles, relying upon that crown law, everything, all judgments belongs. Directed that let the exercise be read on by the assessing authority to re-verify, and if it finds that in the bill that these are there, this can be.
See, here also it has to go back for re-verification.
Your lordship may kindly turn to the assessment order.
This is one.
Setup has been allowed.
Just a minute. Let me complete that. Sorry. There's a second question. If your lordship answer in my favor, then the first
Ramkrishna Rajkumar.
Because just a minute. Sir, this is a case. Admittedly, the period falls within which the amendment had come, and this is pre-amended, and it falls within Rajkumar judgment. But what has happened? Plus, the exercise is done both simultaneously, but without a statutory notice. Your lordship said statutory notice under Section 7(4)
cannot yield to the rule under 15.1. 15.1 is a procedure rule. So 15.1 cannot yield to section 7 for which mandates that there is bound to be an opportunity of hearing. Notice is therefore to be issued, Milords. So that cannot be done away with. What has been done here, Milords? So, Milords, I only pray for, Milords, such a compromise with the statutory provision which is not permissible by judgment of your Lordship could not have been reserved by the assisting officer as they have done here. So if that is your Lordship accept the judgment of that, Milords, and there is also apparently also, because had there been a notice, probably the exercise which your Lordship now proposed to ask me there could not have happened for last 20 years. It could have been done there and there. So therefore, why now? So I think your Lordship fairly, my humble submission is your Lordship may kindly, this may be kindly be followed, this Rajkumar, Kishan Kumar, and so that the fast may not be also. If your Lordship subject to your Lordship.
So even in Rajkumar, they said it will go back for them to give a reasonable opportunity.
That is also, I mean, those, this is again for a long time.
I know, but what to do?
Your Lordship.
I leave it to your Lordship.
Can I, Your Lordship?
Yes, yes.
Your Lordship, so far as the Ramkumar case is concerned, Your Lordship, Rajkishan Rajkumar, Your Lordship, that is the base judgment assessment here, Your Lordship. This is not the base judgment assessment. This is the assessment completed on participation. Your Lordship, what the assessing officer has done, Your Lordship, the assessing officer has allowed the raw material. Only so far as the statutory notice is concerned, my learning seniors argument is that. Your Lordship, so far as the section 7.4, Your Lordship, section 7.4, Your Lordship, at the pre-amended stage, Your Lordship may kindly look into section 7.4. Reasonable opportunity for hearing is to be given, Your Lordship. Section 7.4.
That's all he's asking.
Your Lordship.
He's only asking that.
Your Lordship, reasonable opportunity has been given. So far as the Rajkumar case is that is the base judgment assessment. Here, let me come. Here, this is not a base judgment assessment, Your Lordship. So far as the base judgment assessment, only reasonable opportunity can be issued, granted, Your Lordship. Now, Your Lordship, so far as the statutory notice is concerned, Your Lordship, so far as section 7.4 clearly does not restrict, does not mandate so far as the statutory notice. But notice have been given, notice have been issued, and simultaneously assessments have been completed, and on his participation, the assessment has been done. Your Lordship may kindly turn to section 7.4.
It's not an omnibus opportunity, sir.
Your Lordship, 7.4.
All right, let's see 7.4.
If no return, Your Lordship, pre-amended, that is just below of the provision. Page 15 of this OET Act, Your Lordship.
Yes,
if no return is submitted,
yes.
If no return is submitted by the dealer under subsection 1 within the period prescribed, or if the return submitted by him appears to the assessing authority to be incorrect or incomplete, he shall assess the dealer to the best of judgment recording the register for such assessment. Provided that before taking action under this subsection, the dealer shall be given a reasonable opportunity of providing the correctness and completeness of the return submitted by him. So, Your Lordship, here, the assessment has been done on participation. So this is not a, Your Lordship may kindly turn to page 31 and 32 the assessment order under section 7.4, where everything has been, whatever raw material setup has been claimed, that has also been allowed on verification, Your Lordship.
Let me clarify one point. Probably my friend is missing that. If Your Lordship will say assessment, just a minute, because you are not pointing out that, so I am humble duty to, because here, my friend wants to say GTO is accepted. Well done, that's accepted. TTO is accepted. Only what has been happened? In spite of accept GTO, there is demand of 9,50,000 because the claim of credit which I have claimed by virtue of a statement which I have annexed petition by Annexure 2 has not been considered. Here says GTO accepted. But the credit which I have claimed, Milords, that has not been given. So therefore, that is to be, had the opportunity given, I would have produced documents and it could have dealt it and passed. So you cannot say...
No, but it wasn't a best judgment assessment. I think what he's trying to say is, this is a case where return was filed.
Absolutely.
If a return was filed, there's no question of 7.4 applying, because 7.4 applies only if no return is filed.
No, sorry.
Both circumstances.
No.
7.4 you wrote, and if the return submitted by him appears both.
Then what do you say to that?
My submission is that it is not a base judgment assessment. after participation, after
No, no,
verification.
participation means what? What is participation?
Your Lordship, basing on the books of
No, no,
accounts.
he has filed a return. All right.
Your
He has filed a return. Was there a hearing done?
Your
No, no hearing was given. See, after return is filed, he straightaway passes the assessment order, ignoring this annexure 2.
No notice, no hearing. Yes, that is what I
Correct.
filled it.
So the second part of 7.4, this is what he's argued.
Your Lordship may kindly turn to page 32. On that aspect, Your Lordship is absolutely right.
Yeah,
On
that's a short point, sir.
On verification, it has been passed.
Without his participation, see, you should have given a notice to him and then you do whatever. All right.
Your Lordship may kindly.
Yes, yes. You say the present revision petition by the SSC arises from an order dated 29 March 2007 passed by the Orissa Sales Tax Tribunal, Cuttack, bracket Tribunal, in essay number 56, bracket ET of 2006-07, dismissing the petitioner's appeal against an order dated 21st November 2005 of the Assistant Commissioner of Sales Tax, bracket ACST, Sundargarh Range, Rourkela, confirming an assessment order passed by the Sales Tax Officer, bracket STO, Rourkela 1 Circle, raising an extra demand of rupees 954,611 on the SSC under the Orissa Entry Tax Act 1999, bracket OET Act, paragraph. While admitting this revision petition on 13th November 2007, January 2007, is it? Or November? November 2007. The following questions were framed for consideration by this court. Take questions 1 and 2 at page 18, paragraph. The background facts are that the petitioner is a dealer registered under the OET Act, engaged in the manufacturing of MS rounds, plats, angles, etc. in its re-rolling industrial unit. For the purposes of manufacturing the above products, the petitioner purchases iron scraps, bracket, oblique defective plates, oblique cuttings, rejects, which is then used as raw materials from various registered dealers. Full stop. These are purchased from various registered dealers in the state. In this case, the purchases for the period in question were made essentially from the Rourkela Steel Plant, bracket RSP. While effecting such sales, RSP is obliged to collect entry tax and therefore the dealers, including the present petitioner, while purchasing such goods from the RSP, had paid already entry tax. Full stop. While filing its return for the year period in question, the petitioner claimed set off of the entry tax already paid for the period in question, that is 2003-04. Paragraph. The grievance of the petitioner is that the assessment order was passed by the STO for 2003-04 on, what's the date?
Date is not clear. 31/8/2004. But the order
31/8/2004.
is signed on 30/8/2004.
On 30th August 2004, without giving any set-off for the entry tax already paid. Full stop. After the appeal by the SSC was dismissed by the ACST on 2nd January 2006, the SSC went before the tribunal, which too has dismissed the SSC's appeal. Paragraph. Section 7(4) of the OET Act reads as under. Reproduce the whole of 7(4). The A to A, this flag. The proviso to section 7(4) of the OET Act makes it clear that where it appears to an assessing authority that the return submitted by an SSC is open quotation incorrect or incomplete, unquote. Such assessing authority can assess the dealer to the best of his judgment for according reasons. However, the proviso makes it mandatory that before doing so, the assessing officer shall give a reasonable opportunity to the dealer, open quotation, of proving the correctness and completeness of the return submitted by him, unquote. In the present case, the admitted position is that the SSC did file a return, but the impugned assessment order was passed on 30th August 2004 without any notice to the petitioner. Full stop. The mandatory requirement of this provision has been emphasized by this court in its decision in Ramkrishan Rajkumar versus Assessing Authority 139 2005 STC 450. Full stop. There, in similar circumstances, while setting aside the assessment order, the matter was remanded to the assessing authority for a fresh order to be passed after providing the SSC an opportunity of being heard. Full stop. Learned counsel for the department is unable to dispute the fact that no notice in terms of the proviso to section 7(4) of the OET Act, as it stood at the relevant time, that is the year 2003-04, was provided to the SSC before the impugned assessment order was passed. Paragraph. On that short ground, following the decision in Ramkrishan Rajkumar versus Assessing Authority Supra, this court sets aside the impugned orders of the assessing authority, that is the STO, and the corresponding orders of the ACST and tribunal, and remands the matter to the STO for a fresh decision after hearing the petitioner on a date to be informed to the petitioner at least 1 week in advance. Question number 2 is accordingly answered in favor of the SSC and against the department. That view of the matter, question number 1 need not be answered.
Question number 1, in terms of this Utkal Steel's case under the OVAT Act, similar, that may be also considered along with while doing assessment.
Your Lordship, so far the question number 1 is concerned, he has claimed 10,42,000. Your Lordship,
yeah, you say while hearing the petitioner afresh and passing the fresh assessment order, the assessing officer will take into account the submissions made by the petitioner vis-a-vis question number 1 framed here in number, which is accordingly not being decided at this stage by this court. Right.
Problem.
List item 25.
May I please, Your Lordship? Whereas I'm appearing for the first 2 items. The issue is somewhat similar to what my learned senior argued just now regarding the setup under the OSC Act. I have purchased iron and steel goods which is subject to first point tax bill.
Right.
And subsequently, I have also purchased from subsequent sellers. And the parameter provision under the OST Act suggests that if tax paid
on raw material, I'm entitled
That form
to
34 and all.
no matters. Just note note appended to list C minus.
OST, yeah.
Taxable list C.
Yes.
OST Act.
Yes.
Note 1 minus. The amount of tax payable in respect of goods specified in serial number such and such is OST rate 68, my lords.
$68, is it? What?
Page.
Here it is. Note 1. Yeah.
Note 1 minutes. The amount of tax payable in respect of goods specified in serial number such and such, I fall in the serial number 69, my lords.
Right.
And shall be reduced by the amount of Orissa sales tax paid by him on raw materials and consumables subject to tax on purchase turnover and or tax collected from him by the selling dealer
shown separately
on
body.
the body of the bill. My lords, the difficulty arises, my lordship may visualize that iron and steel goods.
We decided something only a few days ago. Just buy from two separate streams, but not showing it in the body of the invoice.
My lords have.
We then said that they were not able to demonstrate that they had paid tax on the body of the invoice, and so we disallowed.
In this case, I have not given an opportunity to demonstrate that whether the tax has been paid or not. My learned senior just rightly pointed out the decision
You
of.
also did not get notice.
I have got notice, madam. That was under the anti-tax of this. I have got notice. I have appeared, but they simply disallowed my claim of set off because in the body of the bills, tax was not separately shown. But they did not appreciate my submission that I have also purchased from successive sellers, though which cannot collect or charge the tax on the body of the bill. Because it is the iron and steel goods are subject to first point tax paid. This first seller, that is maybe RSP or sale, will be charging the tax. But subsequent seller from whom I purchased, my lords, they cannot charge the tax on the body of the bills. That is the only limited question.
But you should show their bills then.
They,
if
they assessing
of the sale by RSP to your seller.
RSP to my seller.
That bill you should show.
That bill, that limited opportunity of the assessing
Everything
of.
has been verified. At page 27, tribunal's order, in the last paragraph, last portion. Page 27. Therefore, let's see, since the appellant does not process, here let's see, just 10 to 15 lines above. 1/4/2001. Since the appellant does not process or fabricate the finished goods in dispute, it cannot be said that those items are covered up by serial number 68 of the taxable schedule under the OST rule. We have also perused serial number 69. What my learned friend has said, he is coming under 69. Of the aforesaid schedule in which it has been mentioned that finished products of iron and steel re-rolling mills are subjected to tax at the rate of 4%. There is incorporation of cast iron products, so-and-so cast iron and ductile iron 69 with effect from 1/3/2002. Therefore, it is clear that finished product of the dealer cast iron product were not in the list of serial number 69 prior to 1/3/2002. Further, as it transpired from the purchase bill produced by the dealer before learning the STO SCST, tax has not been collected separately on the raw material in the said bills.
No, so he's saying this is his own bills. He says he's prepared to show the bills of RSP raised on his seller.
Your Lordship, he has submitted the bill.
No, he has submitted his own bills.
Your Lordship.
By which he purchased. We are talking of the bills of the previous transaction.
But he is coming since 69, entry 69 with effect from 1/3/2002. And this is the period 2001-2002. So this 69 is not coming into picture. So only 68 will come into picture. So 68 says that.
68 is also covered by the
Not
note
treated
1.
as raw material, Your Lordship.
68 is also covered by note 1.
Your Lordship, note 1. Note 1. 68 is covered by note 1.
So anyway, is to be given an opportunity. That's all he's asking, sir.
This issue has been dealt by your lordship in this
assessment
Utkarsh to this case, my lords, where my lordship has been pleased to remand the matter, giving an opportunity, simple opportunity.
Same judgment which he was just showing.
Yes, madam.
You see, admit You say the present revision petition by the SSC arises from an order dated 31st July 2008, passed by the Orissa Sales Tax Tribunal, Cuttack Bench, Cuttack, bracket Tribunal, dismissing the SSC's essay number 2890/2004. There's a whole list of matters here.
I am appearing for first two matters only, my lords.
In the first two, it has been disallowed. In the other state revision. In other, those have been allowed.
In subsequently, my lords, in my case, petitioner's case, my lord, subsequent years, the tribunal has allowed.
I see. What about this Bisra steel? That's also same.
In those cases, it has been allowed.
No. The first two are Ginny.
Yes.
The first two are identical.
Yes, my lord.
Only 2 different years.
2 different years.
Which is the first one is which year and second one is which year?
First one is for 2001-2.
They are separate orders at tribunal or common order? Separate orders.
Separate order.
Okay. For the year 2001-02. Thereby affirming the order dated 31st July 2003 of the Assistant Commissioner of Sales Tax, bracket ACST, Sundargarh Range, which in turn confirmed the demand of rupees 268,337 raised by the sales tax officer, bracket STO, Rajgangpur, under section 12, bracket 4 of the Orissa Sales Tax Act 1947, bracket OST Act. Paragraph admit the following question of law is framed for consideration.
But I'm not pressing.
Just the first one is enough.
I'm not pressing for one, my lords.
One you're not pressing.
2, 3, 4 are interlinked.
Yeah. I think just 2 is enough.
My lord.
Just reframe question 2 from page 10. Paragraph. The admitted facts are that the petitioner, which is engaged in the manufacture of CI pipes and fittings, manhole covers, etc., purchases steel scrap and steel products from a seller who in turn purchases it from Rourkela Steel Plant, bracket RSP. Full stop. In terms of note 1, entry 68 and 69 of the OST rate chart dash P8 appended to the schedule to the OST Act. The amount of tax payable in respect of goods specified in entry 68 and 69, open quotation, shall be reduced by the amount of Orissa sales tax paid by him on raw materials and consumables. Just take 8. Up to explanation. Paragraph. In the present case, on the short ground that the invoices produced by the petitioner SSC did not separately show the tax already paid on the purchase of the goods by the petitioner's seller from RSP, the set-off has been denied to the petitioner. Paragraph. Relying on the decision of this court in Utkal Steels v. State of Orissa, 1965 GSTR 373, it is contended by counsel of the petitioner that the petitioner ought to have been given an opportunity to produce the invoices of its seller raised on such seller by the RSP, which sold the goods, the raw materials, on which entry tax already stood paid by the, on which the sales tax already stood paid by the seller, the petitioner's seller, sorry. Paragraph. A perusal of the impugned order of the tribunal reveals that there is no reference made to any invoices produced by the petitioner, which have been raised by RSP on the petitioner's seller. So the reference is only to the invoices raised on the petitioner by its seller, which obviously does not contain endorsement on the body of the invoice that tax is already being paid by the seller while purchasing the raw materials from RSP. Paragraph. Mr. Sunil Mishra, Leonard, Additional Standing Counsel for the State, is also not able to dispute the above fact. Paragraph. Consequently, following the decision of this court in Utkal Steels v. State of Orissa, this court sets aside the impugned orders of the STO, the ACST, and the tribunal, and remands the matter to the STO for a fresh determination after giving the petitioner an opportunity of being heard, and in particular for the petitioner to produce before the STO copies of the invoices raised on its seller by the RSP, which would reflect the tax already paid on the raw materials purchased by the petitioner's seller. The petition is disposed of in the above terms. The questions are answered in favor of the petitioner and against the department, and the petition is disposed of in the above terms.
Obliged.
1 and 2, sub-items 1 and 2 are disposed of, 69 and 68.
So far as
You say
sub-item
68,
number
you
3,
say, in view of the order passed by this court today in STRAV 69 of 2009, which pertains to the year
2001, 2 minors.
2001-2, the present petition by the SSC, which pertains to
3-4. 2003-4.
2003-04 is also allowed in the same terms. And the matter is remanded to the STO for a fresh decision in terms thereof.
Your Lordship, so far as the sub-item number 3 onwards, Your Lordship, I may be permitted to argue. Your Lordship, the question of law has already been admitted by the order dated 10th January 2013.
But no notice is issued, looks like.
Your Lordship, already question admitted.
No, admitted is one thing, sir. Unless notice goes, how this other side is going to come to the court?
Your Lordship, notice also dispensing is done. Stay has been made. And issue notice to the opposition.
No, but the same question, sir. Question 2.
No, question number 2, Your Lordship.
It's the same question.
What here happened? A proportionate whatever the tax payable, and only that much of tax paid has been adjusted. Setup has been granted. As per the note 2. Your Lordship may kindly look into that list, see note 2. The first question is same, what Your Lordship has decided. So far as the second question, whether on the fact in the circumstance of the case, committed error in law in holding that setup of sales tax is required to be computed on the basis of sales tax paid by a manufacturer on purchase of raw material in a financial year against sales tax due in that financial year on the sale of finished product out
I
of
think
such
this also answered. This has been answered in some other court.
No, Lordship, only to that much amount. Your Lordship,
proportionate.
Your Lordship, proportionate.
Actually, that I have agreed with the state in some other judgment which just passed last week.
Sorry. But that is...
Again, we're answering the same question. This proportionality, we agreed with the state contention and we passed a judgment just the other day. And that was under the OST Act. We've quoted the language also. The language of the section says that, right?
By tomorrow, I may be permitted.
No, let's read the... But here, there's nobody appearing for the other side. We don't know if notice is served.
In
the order itself,
you are referring in all the cases. You should have all those.
What's the tax effect here?
Your Lordship, tax effect is much more.
4,86,000.
All the cases are much more tax effect.
No, but without service of notice on the SSC, how can we proceed here?
Notice has been issued, Your Lordship.
Issuing is one thing, sir. Whether it's served or not, we have no idea.
Your Lordship.
AD card returned. In each of the matters. Just see, there are so many matters here.
And also appeared opposite person. Appeared in next.
In Sriram Roller, somebody's appeared.
Your Lordship. Sriram Roller appeared.
Mr. Kurmi.
Your Lordship.
Pardon, minutes. STRAB 104, 105, and 108. I have entered appearance minutes. There is no instruction from the party minutes. I have already handed over the petition, but there is no.
Or it will be allow your petition. We pass the order. You see the petitions are allowed. We pass the detailed order. You say none is appearing for the. You say in 3 of the STREVs, counsel appearing for the SSC states there is no instructions. In the other STREVs, in 3 of the STREVs, that is STREV 104, 105, and 108, it says he has no instructions. In the other STREVs, despite service on the opposite side, opposite party, none appears. Then you say the following questions are framed and both questions are answered in favor of the state and against the SSC. The impugned order of the tribunal is hereby set aside. Dictate the detailed order.
I'm sorry, Your Lordship, I could not assist properly.
That's all right. That's all right. Okay.
But you should have one volume, Mr. Misra.
Mal.
All the important, because similar issues are involved. So you should have a separate volume.
Are you aware? No. All right. We just passed it to not even 10 days ago.
That will help.
Right.
Weekly list item 26.
So before your lordship starts item 23, item 24, there is a modification IA 7, because in view of the order passed, no further order.
That's not necessary. All right. In 24, is it MC 7 of 07? No orders are necessary in view of the above order.
I may be pardoned, my lord, the case which my lordship was referring regarding note 1 and 2. Last week, Mr. Pardy for the revenue was appearing. He can, my lord, assist.
Correct. Probably Mr. S.S. Pardy is appearing.
The case number I cannot recall also.
Correct. All right.
I'll find out and I'll submit.
All right.
Item 26.
May I please, my lord?
Yes.
But see, this case petitioner challenges, the order dated 15/1/2009 by the Annexure 6 passed by the Commissioner of Commercial Taxes.
You can go to the tribunal against this?
No, there is no appeal for tribunal. This is the order passed by the what
in revision. It's a revisional order.
So about a revision power exercised by additional commissioner against the order passed by one additional commissioner.
Oh, I see.
The power and jurisdiction is also under challenge here,
I see.
And I have referred to, I have given copy of judgments,
Your Lordship, in this case, we have filed a counter. In the counter, we have stated, we have submitted.
We have
my predecessor has submitted. The officer.
We have not received any counter. Sorry.
Even we have not got any.
We have not received any counter.
Anyway, what have you said?
We have said that the commissioner has not delegated. The grievance of the petition is that the order passed under section 79(2) has been made so motor revision under section 79(1).
Right.
So since 79(1) has been is a delegated power.
Right.
So once the power has been delegated, 79(1) and 79(2), hence commissioner cannot make any so motor revision to the order passed.
By his own delegate. Yeah, by his own delegate. Yes.
So Your Lordship, in the counter we have stated that section 79(2) has been delegated, section 79(1) has not been delegated. So on this issue, I may take instruction if Your Lordship will permit me, but it is not my conscience that so both provisions have been delegated. But Your Lordship, only one
fact, let my friends say something. Hey, just a minute.
What I have found from the record, I have submitted.
No, that is one. And secondly, on fact, the dispute, very interesting dispute.
Your Lordship, better. This is better, Your Lordship. 79.
Yes, you were saying something.
No, sir. What I'm saying, even on fact, very interesting question is involved. Subject to my learned friend give counter, and I will. That is different. Kala namak, so far as the question involved in this case is kala namak, whether it is salt or not. Very interesting question. And this item is covered by pre-amended notification under entry. That was an exempted entry under 35.
That's the judgment you're.
My lords.
You've enclosed the judgment. Balwant Singh Jagroshandal.
Allahabad.
Correct. Balwant Singh Jagroshandal.
Balwant Singh, yes.
Correct.
But the other one, they have deferred saying that the entry is different. But the principle is because technical rule of interpretation doesn't apply to taxation law. It's salt and sodium chloride. Normally, this is sodium potassium chloride.
No, what did we hold in Koraput? This JK Corp. What did we hold?
That is regarding the jurisdiction, Milord.
I see.
JK Corporation. Both are this annual court judgment, Milord.
So the commissioner has no jurisdiction to revise it, settle law. There is a judgment of this court itself in JK Corp.
You'll see my
Three judgments, Milord. Three.
my respect
Para 9.
let's see is that commissioner has the power to make so much revision. And under section 79(1), he can make so much revision of any order which is prejudicial to the interest of revenue.
But that he can't do if the order is passed by another additional commissioner in revision.
Your additional commissioner here, the commissioner has passed the order.
Impugned order, sir. But the order he is revising is passed by the additional commissioner.
Additional commissioner.
That can't be done. JK Corp says that. Just give him a copy of the compilation.
He must be having that. Para 9, my lord. Para 9 of JK Corporation judgment, my lord.
Para 8. Para 8 and 9.
8 and 9. I think 9 will suffice. The commissioner admittedly doesn't intend to exercise power delegated, that is power of hearing revision applications under section 23(4)A read with rule 79. That power has already been exercised by the delegate. The commissioner intends to exercise the power of revision.
Page 11, Your Lordship.
Sorry, page 11 continues.
Yes.
Yes. Exercise power of rule 80. Exercise of power under rule 80 is not same as exercise by him under section rule 79. It is noted that the legislature in its wisdom put a seal of finality on all orders passed under subsection 4 of section 23 of the Act.
So on this ground, if you allow, that's enough.
Why not?
Enough. If the challenge in the present petition is to an order dated 15 January 2009, passed by the Commission of Sales Tax, Orissa, bracket CST, bracket, in revision case number SU-16/2008-2009, whereby the order dated 5th November 2007 but you'll be setting aside a special additional CST. Additional, but the order dated 5th November 2007.
And one more submission.
Karinja order dated 5th January 2008 of the special additional Commissioner of Sales Tax, bracket Central Zone, bracket special additional CST, bracket was quashed. Paragraph. Although this petition was admitted, no, this appeal was admitted. Yeah, that again he went. Yeah,
at page 22.
No question of law is framed at that stage. The short question of law that arises for consideration of the present cases as under whether in exercise of the power under section 23 bracket 4 bracket A of the Orissa Value Added Tax Act 2004, read with section. This was under the OST Act, is it?
This is OST Act.
Acha.
This is section 79.
Okay, whether in exercise of the powers under section 79 bracket 1 of the OVAT Act 2004, a commissioner can.
I'm sorry to interfere, Lords. Because Annexure 1, the very genesis of collection which you challenge, that was done on 28/10/2006. It comes under VAT, Lords.
That's right. Okay. So the question has to be under 79(1).
Perimeter provision, the judgment related to perimeter provision.
Right. 79(1) of the OVAT Act, the commissioner can exercise a revisional power to revise an order passed by a delegatee of the commissioner, exercising powers under section 79 bracket 2 of the OVAT Act.
Minors.
Question mark, paragraph. The background facts are that The petitioner is a registered dealer under the OVAT Act. Dealing in manufacture and sale of different kinds of spices, condiments, and black salt. Stop. The business premises of the petitioner dealer were visited by officials of the Vigilance Central Division, Cuttack, on 28th October 2006. Stop. It was detected that the dealer was not collecting tax on sale of black salt. Full stop. The dealer stated that he was not aware whether the said product was a taxable item. Full stop. Nevertheless, he agreed and opted to pay tax in the sum of rupees 173,918 at 12.5%. Nevertheless, the dealer preferred a revision petition under Section 79(2) of the OVAT Act, which was heard and disposed of by the Special Additional CST (Central Zone) by the order dated 5th November 2007. Following the decision of the Allahabad High Court in Commission of Sales Tax versus Balwant Singh Jag Roshan Lal, 1970, 26 STC 129 Allahabad, holding that black salt or kala namak is a species of edible salt.
The entry is different, you know.
No, we're not talking the entry numbers at all here, sir. The revisional authority concluded that the collection of tax was illegal and directed its refund. Stop. By the corrigendum order dated 5th January 2008, the money receipt was quashed and the money receipt issued to the dealer was quashed and the refund was directed. Paragraph. It appears that the CST, exercising powers under Section 79(1) of the OVAT Act, decided to suo motu, is it?
Suo motu.
Revise the above order of the special additional CST and issued notice to the petitioner. Full stop. One of the preliminary objections raised by the counsel for the dealer before the CST was that no further suo motu revision would lie once the power has been exercised by a revisional authority after being delegated such power by the commissioner. Full stop. In support of such contention, reliance was placed on the decision of this court in JK Corp Limited versus Sales Tax Officer, Koraput 2 Circle, 1999 115 STC 681, Orissa, and Orient Paper Mills versus State of Orissa, 1988 70 STC 333, Orissa. Paragraph. However, in the impugned order, the CST observed that the provisions of the OVAT Act concerning revision are differently worded from the corresponding provisions in the repealed Orissa Sales Tax Act 1947 OST Act. And on making a comparative analysis, came to the conclusion that CST could, on his own motion, revise any order passed by an additional CST. Paragraph. As far as the merits was concerned, it was held that black salt is not the same as common salt and was not exempt from sales tax. So on both the above grounds, therefore, the CST proceeded to quash the order passed by the special additional CST. Paragraph. This court has heard the submissions of Mr. Jagavanta Sahul and a senior counsel appearing for the petitioner, and Mr. Sunil Mishra Leonard, additional standing counsel of the department. Paragraph. In Orient Paper Mills versus State of Orissa, this court had occasion to first consider the scope of the powers of the delegatee and thereafter the powers of the delegating officer. So it must be noticed at the outset that the above case arose under the OST Act and the corresponding provisions of the Orissa Sales Tax Rules 1947 (OST rules). It was held that under Rule 80, the CST did have suo motu power to revise an order of a sales tax officer.
No, that is an application. The revision filed an application. Against that sales tax officer's
But-
order.
And full stop. There was, however, an exception provided in section 23 (4) small d of the OST Act, according to which the commissioner could delegate his revisional power to another person appointed under section 3 (3), such as an additional commissioner or a deputy commissioner.
Small interruption, my lords. In that chart, my lords, you will find Rule 119 and right-hand side Rule 80. Rule 80, Special Additional Commissioner was there earlier, but under Rule 119, Special Additional Commissioner is not there. Your lords, you can find even in the all the officers by designation there. Special Additional Commissioner is not there in Rule 119 for so much power.
Yes, sir.
I think
Yes, for that reason,
it's not there. For that reason.
suo motu revision power has not been delegated.
No, no.
What I'm
Or revision by Commissioner suo motu. Against all these officers, Commissioner can exercise so much power, but from that list of officers, Special Additional Commissioner is not there, which is there earlier in OST Act. That is under Rule 79, Rule 80. Not in 119, it is not there. I find other designations are there, not that designation is not there.
It was concluded by this court on an analysis of the provisions that, as under this B to B. Paragraph. Subsequently, in JK Corp Limited, the same question was addressed by this court. And it was concluded in para 10, para 9 and concluded in para 9 is under C to C. Paragraph. In the instant case, in the impugned order, the CST has noticed the provisions of the OST Act, the corresponding provisions of the OVAT Act, but failed to notice that while Rule 119 of the OVAT rules talks of the revision by the Commissioner, Suomoto, of orders passed by an additional Commissioner, it does not include, as was done under Rule 80 of the OST rules, the power to revise an order of a single quote special additional commissioner, unquote. Stop. In that sense, the OVAT rules do not permit revision by the CST of an order of an additional special additional CST.
Beg your pardon, Your Lordship. So Rule 119 itself says that special commissioner, Your Lordship. Special commissioner, also my Lord Senior will agree with me. There is no post of special commissioner, special additional commissioner.
So that is not there in the wording of the rule. It's not there.
Your Lordship, that revision by the Commissioner Suomoto, that special commissioner is there, or special commissioner. Your Lordship, additional commissioner of sales tax or special commissioner of sales tax.
But the order is passed by special additional commissioner.
Special commissioner post is not there.
Oh, it's all right, sir. It's not written here. It's not amended. So we won't go by that. In any event, even under the OST rules, in view of the aforementioned decisions, the power of a CST to revise the order of an additional special additional CST was not recognized with this court. Stop. Paragraph. In that view of the matter, the court has no hesitation in answering the question framed in the negative, that is in favor of the dealer and against the department, by holding that in exercise of the Suomoto revisional power under section 79(1) of the OVAT Act, it is not open to the CST to revise an order passed in revision by his own delegate, that is the special additional CST, in exercise of the powers under section 79(2) of the OVAT Act. Yeah. Paragraph. The impugned order dated 15 January 2009 of the CST is accordingly hereby set aside. The revision petition is allowed. No order is disclosed.
The word revision may kindly be said as appeal, because it's statutory appeal.
This one is it?
79(7). Before Lordship, this is appeal.
Okay, the appeal is accordingly allowed.
Minor.
All right. OTC is actually an appeal, is it?
Appeal.
I see. Yes.
All the revision may be replaced by appeal.
All right.
Obligation.
Weekly list item 27.
Lordship, item number 27 and 28 are covered by the judgment of Honorable Supreme Court insofar as that the anti-tax matter is concerned. The Law and Tribunal has passed the order by cognizing the judgment of this Honorable High Court in Reliance Industries case, Your Lordship. In Reliance Industries case, this Honorable Court at Para 30, even though it has been declared that the Act has been declared as intra-virus, but at Para 30 of that said judgment, this Honorable Court has said that which is not manufactured within the state, if that has been brought from outside of the state, then anti-tax cannot be levied. Subsequently, at
Para 123, the Supreme Court has.
Honorable Supreme Court, it is a special case in Reliance State versus Reliance Industries, where Para 30 has been reversed, Your Lordship. I'm sorry, Your Lordship, one copy is there. Your Lordship, Para 30 has been reversed. So it is to be allowed in favor of the state.
All right. In view of the judgment of the Supreme Court of India, dated
28th March 2017.
28th March 2003.
17.
In civil appeal number 6474-7 6798 of 2017, bracket State of Orissa versus Messrs. Reliance Industries Limited, bracket. The impugned orders dated. The impugned order of the tribunal in these petitions is hereby set aside. The petitions are allowed accordingly.
Weekly list item 29.
Your Lordship, Your Lordship, item number 29 the several revision petitions, Your Lordship, but the question of law is one. That is the same. Your Lordship, here the question of law is that whether chunni and choker, whether these are cattle feed or not. That is the entry here under Entry Tax Act is that cattle feed is taxable. And the learning tribunal stated that chunni is not a cattle feed, that husk.
Yeah, just read.
And choker is not taxable, Your Lordship. The Honorable Tribunal, the single bench of the Honorable Tribunal, that order also I have enclosed, has passed an order of 26 pages by deciding every case law. But the division has passed a 2 pages order without cognizing that single bench order or without referring to it larger bench, has allowed all.
Why should a double bench refer to a larger bench?
Your Lordship, that may not be, Your Lordship, but here,
What is your entry say? What is your entry say? What is your entry? Entry
is cattle feed.
Cattle feed.
Is cattle feed.
So it doesn't use including, it doesn't say including choker and chunni and all that.
Cattle feed. It itself says that cattle feed. And chunni and choker are cattle feed. And that cannot be used no other use of the chunni and choker. And learning tribunal itself says that if chunni is a part of choker, cattle feed. And if it is a part of cattle feed, it is not a total.
Both are single judges, is it?
No. Your Lordship, but this order, the impugned order, is of single bench. Your Lordship, single bench.
Both are single bench.
Both are single bench.
The earlier order is by a chairman.
Your Lordship, as a chairman, and an elaborate order has been passed. Elaborate detail, all the judgments have been taken into consideration, how it will be categorized.
We are not bound by either. We can decide it independently. So the entry is what? Just let's read the entry.
Your Lordship.
Come to page 28. I think the entry is there.
Your Lordship.
This is Entry Tax Act, is it?
Entry Tax Act. Entry is cattle feed.
Cattle feed, prawn feed and poultry feed. That's the entry.
Again, Your Lordship.
Question is whether chunni is a cattle feed, not merely ingredient of cattle feed. Within the meaning of part 1 of serial number 66. Does cattle feed whether or not? No questions.
Your Lordship, learning chairman has passed the order, detailed order, Your Lordship. Detailed reason order.
Inedible. Correct. Cooking and other purpose. Kerala to be for cooking purpose. Yeah.
Document. It's a black gram chunni.
Yeah. Study of the tender call notice published by OMFED shows that 18 ingredients of raw materials such as oil, rice bran, maize, jawar, they all are required.
Your Lordship, we are taking launch of different items.
Yes.
So whether one of the item,
correct,
Your Lordship, different item. So itself, if chunni, if independently chunni will give.
Yeah, this is entry in a tax statute, correct?
Your Lordship,
but it has to be specific.
You can't use that analogy here.
Your Lordship, if choker will be given to cattle, Your Lordship, can it be used any other use other than cattle feed?
Why not? We don't know.
Suppose in Orissa, you use a coconut oil for the oiling. In Kerala, it is used for cooking. So you can't say it is not used for other purpose. In Odisha, you might say, can it be used for other purpose? But in Kerala, they say only edible purpose.
But Your Lordship, that at page 39, the unlearned.
Actually, here you have what is called rice husk is used in art.
Art also.
Yeah, paddy grass is used in art form.
But Your Lordship has interpreted in many cases Many cases that each and every item cannot be put as an entry in the act, Your Lordship.
No, may
So,
not.
Chuni, Chokod, that 18 items.
No. But if it's a tax entry, then it has to be specific. What falls outside it is outside it.
If that tender call notice will be accepted, Your Lordship, that 18, whether that 18 items can be put as
No, they
entry in
can't.
the entry tax.
So what you sell as cattle feed alone will be taxable. All those ingredients of the tax feed, the ingredients of the cattle feed, if you sell separately, you can't say, no, that is also cattle feed.
The same thing can be used for other purposes.
See, the cattle feed as a product is not complete unless this ingredient plus something else happens, correct?
But Your
Yes.
Your Lordship, Your Lordship,
Don't go by general parlance.
but the Lordship Chairman's order is, Your Lordship, it is not binding, but it is, Your Lordship, may kindly go to that order. I leave it to Your Lordship's wisdom, Your Lordship. And all along, Your Lordship, it is the interpretation of the statute.
Correct.
I leave it to Your Lordship. Your Lordship may decide.
All right.
And Your Lordship, I pray Your Lordship may kindly go through that learned chairman's order, because it is a very detailed. I have gone through entire order. I have gone through it. May not be binding, Your Lordship, but it is a reasoned order, reasoned and valid order, Your Lordship.
Yeah, that is favors the department and that's
No, Your Lordship, no, Your Lordship. Not favor, Your Lordship, but it is a logical end, and it is Your Lordship.
Reserve the order. Okay. Orders reserved.
Weekly list item 30.
30, my lords, in this matter, my lord, due to the interim order of this honorable court, the release sought in the main application already during the elapsed time they have already completed.
All right.
So I have
Petitioner states that due to subsequent developments, the petition has been rendered infructuous. It is disposed of.
affidavit. In view of the government made in paragraph 3 of their affidavit, maybe disposed of.
All right. In view of the government in para 3 of the affidavit filed,
disposed of. I am appealing for the opposition
by the petitioners, the petition is disposed of as having become infructuous.
I am appealing for the opposition 3.
All right.
Weekly list item 31.
My lords, no instruction.
No instructions disposed of.
Weekly list item 32.
Even no instruction.
None appears dismissed, not possible.
In item 32, I am for the opposite depend number 3.
All right, sir. All right. Call up.
Weekly list item 33.
None appears dismissed, not possible.
No instructions.
No instructions dismissed, not possible.
Weekly list item 34.
For my lord, no instruction.
No instructions dismissed.
Weekly list item 35.
May I please, Your Lords? Here in this case, in the year 1981, 1 acre of agricultural land was settled in favor of the petitioner, Miller. That is Annex 2. But fraudulently in the year 1985, behind the back of the petitioner,
all right,
the land was settled in favor of the wife of the employee of that Tahsil office. And the entire family of the OP number 6, 4 persons, 5 persons are working in that office. This Honorable Court directed by the order dated 11/8/2014 to inquire into the matter collector, but I filed a modification petition, flag C Miller, to give it to the economic wing, which is the flag C. I have filed the modification of order. Lordship C, flag C. Para 3 I have stated.
These are not the matters to be investigated by economic office.
What is the explanation of order?
They can go to Lokayukta. Your Lordship is, if this is the position and this is the alley, EOW cannot investigate all this.
Yeah,
there is no, they can go to Lokayukta.
Yeah.
This Honorable Court directed, Your Lordship, kindly say, this Honorable Court directed after hearing 11/8/2014, Your Lordship. 11/8/2014.
Yes.
Last but fourth paragraph from the bottom.
Yes.
After perusing the affidavit filed, we further direct the collector Khurda to conduct the proceeding expeditiously and conclude the same at the earliest, and all the parties are directed to operate in the same regard.
and directed for status report. There is no status report
Yes,
as
yes,
yet, I think.
affidavit has been filed twice by the collector.
Hello. Then the investigation be made by because they are working there. The family members are working in the collectorate.
Do you think the collector doesn't investigate into all this?
Even the
My lord, may I, even if collector find that there is some criminal activities, the only course open for them to approach the Lokayukta, because if they are all government servants.
Lordship, there may not be a proper inquiry into the matter, and the proceeding will be. Here, my land has been fraudulently settled in favor of OP number 6 and 7. Not I have any allegation against the collector. There may not be a proper inquiry to that effect, as per the direction of this honorable court.
Because it is against the government servant.
Yes, correct.
Can go to
Your lordship is.
I
it is
have
an allegation against the government servants.
I have no
you are saying the collector may not inquire into the matter properly. So you should approach the independent body.
No, but you should challenge our order then. If you are aggrieved by our order asking the collector to conduct an inquiry, you should have challenged the order.
Well, you
can ask for a modification. It's not a modification.
Yes,
it's a review. What you're asking is actually a review.
Well,
you say by an order dated 11th August 2014,
the status report.
This court had required the collector Khurda to inquire into the allegations made in the petition. That a fraud had been committed in granting leases. This inquiry has since been concluded.
Yes, the affidavit has been filed by the then collector. That I am searching for that.
No affidavit.
Yes.
Status report is not there.
No, affidavit has been.
No, this is also affidavit 7th July 2015.
8/8/2014.
Maya, representation Annex 7.
Yeah. Yeah. Since then,
24/7/2013, one affidavit, another is 8/8/2014.
No. There is an affidavit. No, there's an affidavit at page 142. Affidavit dated 7th July 2015.
Yes. That is it.
The last of the since their affidavits have been periodically filed by the collector Khurda, the last of it being the one dated 7th July 2015.
Pardon your lordship, we are appearing for opposing part number.
It is stated that steps to review the wasteland lease cases have been taken. And wherever the irregularity in settlement of government land is noticed, the process has been initiated to bring it back to government khata. It is stated till the date of the affidavit, land to an extent of AC 45.318 has been brought back to the government khata. Paragraph. The court is satisfied that its directions have been complied with. Also, if the petitioner is aggrieved by any further instances of alleged fraudulent transfers, it will be open to the petitioner to approach the Lokayukta for appropriate directions. The petition and the pending applications are disposed of.
Lordship, we are appearing for opposing part number 6 and 7.
Repetition is disposed of. Yes.
Quickly list item 36. Item number 36.
So in this matter, there are two issues. One is that with the Contract Labor Regulation and Abolition Act 1970 in force, whether the Section 10 reference under the Industrial Disputes Act 1947 is maintainable. And second, the Industrial Tribunal has put the onus on the management to prove that he was absconding. There are two issues here, whether the Industrial Tribunal could have put the onus on the management Now, as far as the first one is concerned, there are judgments of the Delhi High Court, there are judgments of the Rajasthan High Court that with the coming into force of the Contract Labor Regulation and Abolition Act 1970, the reference under Section 10 is not maintainable under the Industrial Disputes Act. As far as the second question is concerned, may I just hand over? I have just one copy of the judgment, if your lordship, I can hand it over. But before that, if your lordship will go to the award, it starts at page 16.
What's the relief granted?
The relief granted is either reinstatement with 25% back wages, and if the work, because we are admittedly contractor, this is a contractor establishment. We take work contracts, and the work contract is over. So now the only issue which remains is 50,000 rupees in lieu of reinstatement and back wages.
No, the relationship between you and the opposite party, number one,
yes,
is employer-employee.
Yes, you're
not a principal employer. You are the principal employer vis-a-vis that employee.
Absolutely.
So why can't the reference lie? You are not a contract laborer.
But your lordship will.
She's not your contract laborer. She's your employee.
Can I just show at page 18 where the finding starts?
Yes.
Now, with regard to the judgment of the Supreme Court, which I have just handed it over.
Yes.
If your lordship will look at page 18, the paragraph 6.
Yes.
The last line. Therefore, the burden lies on the management to establish that this is a case of voluntary abandonment of employment. Now, the Industrial Tribunal, by recording this, proceeds that I am responsible. I have to show that, which I just handed over. This is almost a similar case of the Supreme Court. If your lordship will have paragraphs 29 and 31. I'm sorry, I don't have another copy of that judgment. I'm extremely sorry. Your lordship will look at page 29. The initial burden of proof was on the workmen to show that they had completed 240 days of service.
No, why? That's not the issue here at all.
No, I'll just go further. Your lordship will look at if your lordship will look at even
only
with regard to abandonment of service also, it was the workman to prove it.
No. The issue here is the validity of your termination of the services. That's it.
No. But
it's not an issue of regularization.
I never terminated. That was my stand before the Industrial Tribunal.
But you have to show that you did not terminate. You should show the attendance register. You should show things to show that she abandoned service.
The tribunal goes on to calculate, in fact, there's a letter which, of course, I have not filed that, but I must concede that letter is not there. But I have stated in my writ petition that the LCR may be called for, and the letter is on record where he says.
Very important. Just see what the tribunal points out at page 19.
Yes.
Even no evidence is adduced to show that when the workman failed to report, the management did not serve any notice asking her to report for duty. So that's a very basic thing. If some employee is not turning up, you definitely issue notice saying, how come you've not turned up?
But between his period of suspension, he files a representation, which he accepts. That's Exhibit A. I read it from but the LCR is before your lordship. Apparently, the LCR record, the Exhibit A has not been filed in the present writ petition.
Yes.
Exhibit A is not there.
You will write this. So we're not inclined to interfere.
Very well.
You can refer to the order. Petition dismiss will pass the order.
Grateful.
Right.
Weekly list item 37.
That's item 37.
37, 38, 39, 40.
Till 47.
All are the similar matter.
37 to 47.
Yes, my lord. 47. My lords, in this case, my lord.
Filing a affidavit today. The government. Lordship, may kindly have a glance to paragraph 5 and 6. The 4.1 notification was issued. In paragraph 3, I have mentioned 4.1 notification was.
So then in that case, nothing needs to be done, sir.
No. My lord, your lordship, may kindly have a glance to paragraph 5.
They have excluded. That's what
they have excluded our land. Yes.
So nothing remains.
Nothing remains.
In view of
Your
the para 6 of the affidavit
Yes, I have
filed
also
today by the
attached-
petitioners, nothing survives as far as the present petitions are concerned.
My
The
respect,
petitions are
submission,
disposed of.
my lords, this project is undertaken by the Watco, my lords. Watco is not a necessary party here, my
It's
lords.
all right, sir. Petition itself is over now.
I pray that this
All
Watco
the
be necessary.
petition itself is over, sir. He has filed an affidavit saying his land stands excluded.
No, my lords, this entire, because what is my instruction, my lords? The entire is covered, the boundary wall is covered. The
Sir,
entire.
he's filing an affidavit saying my land is excluded. Why should we get into that?
I have to take instruction in this.
No need, no need.
My lords,
He does not want to press his petition. I don't understand what your problem is.
my lords, this,
He says since his land is excluded, he does not wish to press the petition.
my lord, this land.
What is your problem?
My lord, this land to the extent of 37
Anyway,
acres, my lord.
That's all
The
right.
project is confined to a limited area. my
All
lords.
All right.
The entire 37 acres is bounded by this. His land is also be included within the
All right.
boundary wall, my lords.
I have given the
Plan
Google
also, map.
showing that in fact they have excluded my land.
Yeah.
They have put on a boundary wall over the acquired land.
Of the affidavit,
My lords, it is.
counsel the petitioner does
So
not
I
wish
have
to
to
press
file
for
an
any of the
affidavit,
reliefs
my
paid
lords.
for in the present petition.
My lords, I have to file.
Petitions are accordingly disposed of.
My lords,
Your Lordship, if there will be any dispute by the other side, the liberty may be granted to approach this honorable court because now he is
No need,
opposite.
no
my
need.
lords,
sir.
my
No need for
respect
all.
commission, my lords, this entire 37 acres is bounded by boundary, my lords, and this land is included there. And the project, this is limited to a confined to a particular area, my lords. But the entire area is also covered by this is boundary wall means. So that has been acquired and Watco has taken this possession and they have also, this STB has completed and that it has been commenced for last 2 years, my lords.
All right.
So, my lords, this land is within the boundary wall, my lords.
All right.
And no construction has been made by this year. This is a vacant land, my lords.
I have provided the map itself.
My lords,
And according to my friend, since no possession taken, no compensation paid, they have put on the boundary wall beyond our land and they have started the project already since 2017.
We are only recording that you have said this in your affidavit and you do not wish therefore to press for any of the reliefs. We are therefore disposing it off is not pressed.
my lords, I
But
may
in
be
all
permitted to
other
pay.
cases, I am filing also the affidavit except item number 42 where the due to illness of the party, the petitioner could not come.
It's all right.
The
Item
My lords,
42,
my
you say,
respect-
counsel the petitioner states that as
My
per
lords,
his instructions, the
my-
petitioner's land is not included.
My respect submission, my
In the
lords, that my submission may be
Lands
recorded.
acquired, and therefore he does not wish to press this petition. The
My lords,
petition is disposed of as not pressed.
My lord, another WPC has not been listed. That is 15091 of 2012.
Yeah, you say 15091 of 2012. On mentioning it's taken on board. It is disposed of as not pressed
my lords, my submission may be recorded, my
In
lords.
view of the affidavit, madam.
in view of an affidavit filed.
My submission may be recorded, my lords.
We will not, sir, because this is only his submission that we are recording. He does not want to press. We are not expressing any view on that. Yes.
My lords, because of I will be misunderstood, my lords.
No,
My
nobody
submission may-
misunderstand you, sir.
So this submission may be recorded, my lords. That this area is covered by the boundary wall.
So
That-
we have not, if we have accepted a submission, if we have given a ruling on it, I can understand. We're simply recording his statement and saying he does not want to press. I don't see how there can be anything else. All right.
Up to item number 47.
Yes.
Wiki list item 48.
48, Milord, I am for the opposite party. 1 and 2, the.
All right. None appears for the petitioner. Dismiss the non-prosecution. All right.
Wiki list item 49.
None appears. This is non-prosecution.
Wiki list item 50.
None appears. Dismiss the non-prosecution.
Wiki list item 51.
Item 51, my lord, I have no instruction.
No instructions dismissed.
Wiki list item 52.
Item 52, the petition is a covered matter, my lord. Petitioner purchased the land prior to cancellation.
All right. On the ground that
Same order
the
to
land
pass.
purchased by the petitioner was prior to its cancellation by the order dated
Yes.
19 September 1987. The impugned order of the
Interim order
Tahsildar
dated 13
Bhubaneswar is hereby set aside.
till disposal
And
of the revision.
suo motu revision case number 680 of 1987 is restored to the file of the Tahsildar.
No, my lord, perhaps ADM.
ADM.
Additional District Magistrate, sorry. Additional District Magistrate Bhubaneswar. The said case will now be listed before the ADM Bhubaneswar on 21st September 2022, on which date the petitioner will appear along with a downloaded copy of this order. The said revision case will thereafter be disposed of after hearing the petitioner within a period of 4 months. Till then, the interim order passed by this court on 13th March 2013 will continue. Same order in 50.
Yes. Same order in 4 cases.
In 4 cases, right.
But the revision case, as per the cancellation order on the annexure, the revision case should be.
The date of
numbers are different.
Yes, date of the order of the ADM. All right.
Weekly list item 53.
Let's say item number 53 and 54 are related to the 2J, section 2J of the Orissa Entity Tax Act. So these cases may be tagged with WPC number 14,069, 2012. Dabur India, where the virus has been challenged.
When are
I've
those
given
listed?
a list of the cases. I've given a list. Of the
List along with, when are those listed?
1406.
Date has not been fixed.
Date has not been fixed, Your Lordship.
All right. Yeah. List along with these cases. It's the date, yeah. 5th December.
Obliged, Your Lordship.
Weekly list item 55.
None appears. This is not possible.
Weekly list item 56.
56, no instruction.
No instructions, dismissed.
Weekly list item 57.
None appears. This is not.
Weekly list item 58.
8. None appears. This is
No,
not
my
possible.
lord, I am for the petitioner.
58.
Weekly list item 58, my lord.
Carry on, carry on.
My lord,
Carry on, madam.
my lord, this is a read petition, my lord. Before this, already these read petitioners were in this court, in this honorable court in 12,213 by 2012, my lord, in which this honorable court ordered the sub-collector to dispose of the representation filed by the present petitioners. My lord, the case of the petitioners are like this, my lord. The petitioners are the hereditary Sebayas of Lord Goddess Viraja Thakurani, and there are four branches of Sebayas, my lord. One Pani, and then Pani Koro, and Pani Rai, my lord. And that Pani Sebayas have already filed one title suit, my lord, in previously, which was dismissed, my lord. Title suit number 283 of 37, my lord.
Where is that order?
My lord, that is in page 7, my lord. Page 7 in annexure 1.
There is no interim order here. What has happened in the meanwhile?
My lord, only.
My lord, there is a provision to decide by Assistant Commissioner of Endowment, 41E of the provision, whether any person or entitled Orissa Hindu Religious Endowment Act, my lord. Orissa Hindu Religious Endowment Act, there is a provision.
That's fine. What is the status now?
What is the status now?
Present status.
Present.
Who's offering this pujas?
My lord.
If the petitioners have not got interim order in their favor, some other group must be offering pujas.
No, my lord. No, my lord. My point is that, my lord, the sub-collector, being the managing trustee, has no right to to take evidence, my lord, and to pass this order. This is my point, my lord.
No. What has happened as a result of the order?
Result of the order, my lord, the parting guys have been deprived from doing
Correct.
the seva
So
puja.
who else is now doing puja?
Yeah, other branches, my lord, the collectors, the sub-collector stated that, ordered that to do puja, but not to toss goddess, my lord. Do puja, but not to toss goddess. This is a peculiar order, my lord.
Anga Seva, my lord.
No, it is not a peculiar. There is a system.
System, my lord.
Where is the system,
Some
my lord?
Sebayas are not entitled to touch the goddess.
Hmm.
They will come out, they will have niti outside the goddess. To touch there is a special right conferred on the.
No, so because they were deprived of that right,
that is why
somebody else must be enjoying that right.
that
Other person is not a party here.
No, my lord, in the civil suit, my lord, I am basing on the civil suits order. In that civil suit, my lord, the court has held that we are able and we have right to do all the Seva Puja, including touching of the goddess, my lord. This order is Annexure 1, my lord.
You're not following what I'm asking you.
My lord.
Since there is no interim order in your favor, in these years, when was the interim order? When was the impugned order passed?
Impugned order passed in
16/8/2012. No.
No.
When was the interim order, impugned order passed?
My lord, kindly see, my lord. In 2013.
2013. So in the last 9 years, somebody else must be getting the right to touch the deity.
My lord.
Today, if we allow your petition,
my lord,
that person will lose the right to touch the deity.
No, they will, my lord. Because all the 4 categories will have the right to touch the goddess.
The suit, 1942.
The suit was dismissed.
Suit against these Pani, my lord. The petitioners, my lord, kindly see our ancestors were defendant number 4, my lord.
You'll have to
the
go to the
suit
civil
was
court,
declared in our favor, my
Who's
lord.
going to determine all this? Who's going to determine this whole
My lord,
lineage?
that is my lord. My lord, my point is the sub-collector has no authority to decide that I am the illegitimate child of that Panigrahi, my lord. My point is that nowhere in the
with regard to his status.
My lord, at that time, that point was not raised, my lord.
Yes.
At that time, when Naran Panigrahi was alive in the year 1938, but suddenly in the year 2013, they said that we are the illegitimate child. That means my father was the illegitimate child of that Naran Panigrahi. In 1938, nowhere they said that Naran
This is the problem. This is the problem about representation, writ petition. Then we direct our authority to dispose of representation. This is the whole problem. All this should have gone to a civil court. You took the writ route. This is the whole problem.
My lord, there is also civil court order, my lord. My lord, after that civil court order, they have never challenged that order in the appeal, my lord.
No.
That means
you came to this court,
my lord,
saying you've given a representation.
My lord.
That representation should be disposed of.
My lord.
So you invited trouble. You should have gone to the civil court.
Actually,
now you're saying the sub-collector cannot determine your status and all of that.
My lord, my lord. My point is,
why did you file a representation then to the sub-collector?
Because the sub-collector is the managing trustee, my lord. So we have filed the representation, my lord.
You yourself gave him an authority to decide an issue. When he's decided against you, you now say he has no authority to decide.
No, my lord, the sub-collector has no power.
Exactly. If he has no power. Sorry, madam. You are addressing us.
Sir,
if he does not have power, then you should not have gone to him in the first place.
My lord,
you came to this court saying, ask him to dispose of my representation.
My lord, the representation has been disposed of with another manner, my lord. That is my point, my lord. In the Endowment Act, my lord, there is nowhere it is written that the sub-collector will.
We can permit you to go to the we can permit you to go to the civil court, which will decide the issue independent of the order passed by the sub-collector. That's the best we can do.
My lord.
Counsel the petitioner submits that the sub-collector had no jurisdiction to decide the issue whether the petitioners were in fact the actual legal descendants of the plaintiff in title suit number 283 of 1937. And therefore, the remedies of the petitioner to seek appropriate reliefs in that regard in the civil court required to be preserved. She accordingly seeks leave to withdraw the present petition to pursue those remedies, provided it's clarified that the impugned order of the sub-collector would not come in the way of the petitioner pursuing those remedies. Paragraph. It is seen that the impugned order of the sub-collector came to be passed only because of a representation purportedly made by the petitioner to the sub-collector as managing trustee of the temple in question. In fact, the petitioner had approached this court with writ petition civil 12213 of 2012 for a direction to the managing trustee to dispose of the petitioner's representation. Pursuant to the order dated 16th August 2012 passed by this court in the said writ petition, sub-collector has disposed of the said representation by passing the impugned order dated 14 January 2013. Paragraph. The better course would have been for the petitioner to have in the first place not approached the sub-collector at all, but sought remedies in separate civil proceedings. Paragraph. In that view of the matter, while permitting the petitioners to avail of remedies in separate civil proceedings in accordance with law, and if permissible in law, the court clarifies that in such event, the impugned order of the sub-collector would not come in the way of such forum, independently deciding the issue in accordance with law. The petition is disposed of the above text.
Vehicle list item 59.
59, this matter is infractious, permitted to be withdrawn.
Counsel, the petitioner seeks leave to withdraw the present petition as it has been rendered infractuous. Dismissed as withdrawn.
Vehicle list item 61. 61.
All right, pass over.
Vehicle list item 62.
None appears to sustain prosecution.
Vehicle list item 63.
None appears to sustain non-prosecution.
Vehicle list item 64.
None appears to sustain non-prosecution.
Vehicle list item 65.
None appears to sustain non-prosecution.
Vehicle list item 66.
66 1 week time may be given. File is misplaced, my lord. Only one
chance. You revive it after you find the file.
Only one chance may be given.
No, sir. Counsel, the petitioner states that the file has been misplaced. The petition is dismissed for non-prosecution with liberty to the petitioner to revive the petition in the event that the file is able to be traced.
Vehicle list item 67.
May I please, your lordship. Lordship, at page 13, the document I have annexed to the petition is a ROR. I'm sorry, but it is a Odia vernacular. The ROR stands in the name of the present petitioner.
Page 13.
Page 13, 1-3. Sujata Naik, the petitioner, this is the ROR stands in the name of the present petitioner, my lord. Then, my lord, the land of the present petitioner were acquired by the NTPC as per the old act.
For release of amount, when
yes.
you file writ petition, there are provisions on the Land Acquisition Act.
My lord, compensation was determined when it was.
You have section 30.
My lord, because my vendor, he had approached this honorable court. Lordship may see that order of this honorable court. Finally, that annexure 4, page 20. Finally, on ground of maintainability, the petitioner was disposed of the interim order granted was stand vacated, my lord.
Okay.
Thereafter, immediately annexure 5, I represented the collector. 5 series. Then also annexure 6, page 25, the collector writes to the Tahsildar, please take appropriate action as per the order of the collector in GP number so-and-so, dated so-and-so, report compliance to the person of the collector.
So till they know,
they have not
know what has happened then.
Thereafter, civil suit is filed. He is claiming right, title, interest over the property. My vendor, my lord. That suit is pending since 2009. He had not taken any steps, my lord.
Oh.
Lordship will find
what has happened.
Last
his vendor, he has purchased the property, but his vendor has challenged the sale deed and filed a civil suit. Now this is the dispute, and the suit is pending since last.
Yes, for section 30 only.
Yes, that's your lordship may direct that the suit.
There's a dispute. You go down to section 30, sir.
Unless that suit is disposed of, correct, the compensation cannot
be disbursed.
Rightly, my lord. But I have taken all efforts to contact her. I could not able to contact her money. So lordship may dispose of if there is no legal embargo. They can't be disposed.
All right. Counsel, the petitioner states that the petitioner will pursue remedies and other appropriate proceedings, including the civil suit stated to be pending. The petitioner is disposed of with the liberty is prayed for. Ole.
Weekly list item 68.
668 is permitted to withdraw.
Counsel, the petitioner seeks to
On behalf of
withdraw
Mr.
this
Pal.
petition. Dismissed as withdrawn.
The connected one also? Both?
All three connected.
Yeah, all right.
Weekly list item 69.
The memo is taken on record. Disposed of with no, since the petitioner has no instructions.
Weekly list item 70.
None appears dismissed and not prosecution.
Weekly list for admission item 71.
Well, 71 not pressed.
Not pressed dismissed.
Weekly list item 72.
None appears dismissed and not prosecution.
Weekly list item 73.
And I am for appearing for occupant 2 and 3, my lord.
All right. None appears dismissed and not prosecution.
Weekly list item 74.
Item 74, my lord, counter is not received till now.
That's all right. What is the matter about?
My lord, the matter is about the notification that was issued by the State Election Commissioner for the election of a Panchayat Samiti member.
That's all over, sir. Now it's all infructuous. Due to a flex of time, the petitioner is rendered infructuous. It is disposed of as such.
Weekly list item 75.
None appears dismissed and not prosecution.
If there is a venue noted, my lord, OP number 1.
Weekly list item 76.
None appears dismissed and not prosecution.
Weekly list item 77.
None appears dismissed and not prosecution.
Item 78.
May I please your lordship, this is a matter that the Paleswar municipality is constructing a shopping complex, encroaching the public road, and the station, that is the road from station to stations are very narrow.
Sir,
and
now the
without
shopping
permitting-
complex is
and also,
come up or not?
my lord,
What is status now?
my lord, is now they have filed a counter, the executive officer, municipality, saying that only in order to rehabilitate the street vendors, then they are constructing. Your lordship will recollect your lordship specifically, that is the part, that is the order in a Baleswar flyover bridge case in the paragraph 15, 16 and 19. Your lordship may pass, that is passed your lordship see, that is a earmark places given by the collector for rehabilitation to the vendors, street vendors. But it is not wise for the executive officer.
This has to do with some shopping complex. Sir.
Yes, shopping complex. It is very narrow, and this is the encroaching public road as well as in the drainage, my lord. Then,
so what is today's position, sir?
Position means not constructing now. There is only the plinth level has been constructed, not constructed because there is an order by this honorable 11/10/2017. So not to construct. Your lordship already this honorable court has gone through.
Constructed on that. They have shifted to some other place.
Yes, they
have done that.
No, but not the executive officer is there. Only your lordship passed this first.
Let him tell us what is happening. What is the position?
My lord, only.
Sir, you will not let him speak also.
My
lord, yes.
You will not let him speak.
Yes, my lord.
My lord, shopping complex have been constructed due to stay order from this honorable court that has been stopped, my lord. In paragraph 4, I have mentioned that their main allegation is the road of width of road will be shortage. There are specifically we have stated there will be no inconvenience to the passenger or also other public passenger. Specifically in paragraph 4 and paragraph 6 I have mentioned. Besides, I have enclosed the 2 orders of this honorable court where it has been specifically categorically stated to the street vendor should be
constructed and
that
is a different issue altogether, sir. You first let him complete a statement, then we will hear you.
Page 8, my counter page, internal page 8, my lord, where this honorable court specifically directed to rehabilitate the street vendors in a phase manner. We have procured e-tender notice. They have not objected. Construction was going on, never objected. After half constructed, they have taken interim order. pursuant to interim order, we have stopped construction, sir. There is no, my specific amendment,
Yeah, absolutely.
no,
Yeah.
no inconvenience to the passenger, man.
Right.
And this is your lordship, may only for a moment.
And no
Lordship-
rejoinder has been filed.
My
Sir,
lord-
no rejoinder has
No,
been filed to your counter.
My lord, no, my lord. only-
Then that's it.
Your lordship, only your lordship, see, for a moment, your lordship's order.
Just get.
There is, your lordship, see, that is the collector has already earmarked the places. There is a 14.
That will not
14.
stop, sir.
For
That is a separate exercise.
Street, that is separate for street vendors, for street vendors.
Correct.
According to them.
What does that
But
do with
this is the-
this?
Well, from station to station square, very narrow.
You are
Where is the
all
covering?
encroaching everywhere. What
No,
else?
no, my
Where
lord,
is
this
the covering sheet for
this is
this?
they are encroaching and they are also constructing. That's why your
Where is the
lordship.
covering sheet for this?
Yes, your lordship's order.
No.
First page.
Cost
First page. Cost title, my lord. Sorry, cost title. This REIT application.
I see. All right. The grievance in the present petition was about construction of a shopping/market complex in Balashur city, which according to the petitioners would cause obstruction on the public road, preventing easy egress and ingress for the public towards the Baleshwar railway station. Paragraph. While directing notice to issue the present petition on 11th October 2017, an interim order was passed staying further construction of the market complex. Paragraph. Response to the notice issued, a counter affidavit has been filed by the municipality on 3rd November 2017, where inter alia, it stated in para 8 no, it's stated in paras 4 and 8 is under. Take just para 4 and then para 8. Paragraph. In the last 5 years, there has been no rejoinder filed to contradict the above amendments. Full stop. Counsel for the petitioner points out how the market complex remains half constructed. And in fact, because of stoppage of construction work, some antisocial elements have forcefully occupied the half constructed rooms. Paragraph. The court finds that there is no justification for continuing the interim order passed with this court in view of the above clarification made on affidavit by the municipality. Full stop. Paragraph. Counsel the petitioner refers to some orders, judgment passed with this court on 23rd August 2021. Sir, at least give us interpretation civil 2376 and 8991 of 2021, which concerned the relocation and rehabilitation of shopkeepers operating under a flyover bridge in Baleshwar. Full stop. Clearly, that's an independent issue which has nothing to do with the construction of the shopping complex with which this petition is concerned. Full stop. The court sees no reason why the rehabilitation resettlement in terms of the judgment of this court.
Paragraph 14.
Interpretation civil 2376 and 8991 2021 should in any manner get affected because of the construction of the present shopping complex. Paragraph. Consequently, the court finds no merit in the present petition. The interim order is vacated, the petition is dismissed.
Well, collector may decide this. Your lordship may direct the collector.
So that matter is separate. You're just confusing the two matters.
Only your lordship direct the collector to look into this matter and also accordingly. Your lordship. That's your lordship direct to the collector.
Yes.
To make an inquiry, then thereafter.
Weekly item 79.
May I please, Your Lordship?
Yes.
Your Lordship, this is the public interest litigation for the protection of lives of the victims of rip current. And in this matter, Your Lordships, I have
Rip current.
rip current. That is the lateral current in the sea, Your Lordships.
Why that?
Lateral current in the sea.
Why that lateral current is there?
Lateral current due to which the sea goes normally.
No. Why the lateral current is?
Lateral current. That is
No,
not.
why? Why does it go?
Pardon, Your
Why
Lordship.
that current is required? I'm saying.
That is rip current.
No, what is that?
Raising inside the sea.
Why they raise inside the sea?
Because of the magnetic force of this water and the earth, Your Lordships. There is I have described that also in paragraph.
What is that rip current? We don't know.
That rip current. Yes, Your Lordships.
What is that rip current?
Yes. I am showing you, Lordship.
Don't show, just explain. No need to show.
Actually, it is a lateral. It is not a due to at page 5 also I have described that it is a rip current is a narrow and powerful current of water running perpendicular to the beach, Your Lordships. So these currents may extend to high feet, and it is not simply drowning due to the see pins. Even along the shore, Your Lordships. Suggested some points at page 8, Your Lordships, at para 4.5.
What is the grievance with the current?
At para 4.5.
You're saying there should be life jackets for rescue of victims.
Yes, that should be like, and mainly, Your Lordships, I am praying for the public awareness. What?
How many victims of this rip current have you had in the recent past?
That is why, Your Lordships,
Does it occur
Union of
regularly?
India.
No. Does it occur regularly or during your cyclonic storm, something like that?
No. It can happen any time, Your Lordships. That is not only.
But just have you studied how many a month or year it happens?
The strategy.
Total how many times it occurs? Any statistics you have? Does it occur regularly?
Yes, Lordship. To that effect, what my learned friend has submitted data. I will show Your Lordships at page saying that there will be a record, page 12 of the reply to rejoinder filed by opposite.
There are so many affidavits, madam, already filed. So the last is the fire officer's affidavit dated 29th April 2019.
In 2019, Your Lordships, what they have filed.
Just read that.
Yes, they have at page 12, Your Lordships.
No, para 5. Just read para 5 of that affidavit, 2019 affidavit.
That in reply to the amendments made in paragraph 2 of the rejoinder, it is humbly submitted that opposite party number 3 in his counter filed in the above case has informed that Government of Orissa has declared drowning as a state-specific disaster and made provision for payment of ex gratia assistance of rupees 4 lakhs to the next of the kin of any person who dies due to drowning, which includes drowning due to rip current. As such, the bereaved families of the persons died of drowning due to rip current would also be entitled to such assistance in shape of ex gratia. So the differentiation created by the petitioner between drowning due to rip current and other reasons is only to create confusion about the real issue. So my point is, Lordships.
No, just carry on. Because what they have done.
That in reply to the amendments made in para 4 and 6, of the rejoinder, it is humbly submitted that at 33 strategic points of the sea beach, instructions have been issued by the Department of Tourism, District Administration Puri and Beach Development Committees Puri in English, Hindi and Odia language, which have been installed along sea beach front at Puri at different locations for awareness of the tourists. But it is contrary to the opposite party number 2's counter, your lordships. I may be pardon, your lordships. This is contrary to the counter. The copy of the beach instruction is filed herewith as annexure.
So what more do you want? They are doing all this.
No, your lordship. This is
There are
after
there at Puri.
And then para 8, they've appointed 98 lifeguards.
your lordships. What they have submitted, this is the data of 2012. In
No, 2019.
No, 2019 affidavit, but that particular D/2 is the real affidavit. What?
No, just read. If you read
This
on
is I am reading.
internal page 4,
Internal
there are
page
98 lifeguards working. Just see that.
Yes. At present, there are 98 lifeguards working at the outset. 2 posts are vacant. Odisha Fire Service has issued them uniforms.
Regularly, what I have seen.
Yeah.
They regularly one in the evening time.
They've been supplied rescue tubes, megaphones.
No.
What
Actually,
else you want? Already, all these things are we are talking about.
no, only your lordships, they have annexed at page 8. They have annexed the instruction.
Yes.
Only one line is there. Do not swim without the help of lifeguards.
Yes.
Only one line.
What
So
else
my-
can be done?
My point is, lordships, at page 8 of my petition 4.5, I have only point is, lordships, public awareness may be there.
There are, you see that if you go to Puri, you'll find them always holding a megaphone and making announcements.
Well, let's
Actually, what?
1 minute. Yeah.
What opposite? This is the affidavit of opposite part number 1 Union of India, and it is contrary
No,
to
this is a fire officer. This is a fire officer's affidavit. Opposite party number 4.
Yes.
Chief fire officer.
Yes.
He's the best person to talk about rescue.
Yeah, let's see. Page 14 is the 2012 document where, and page 13 is also 2013 document where it is at first paragraph. We have issued beach lifeguard uniform to the above 40 passed out lifeguards to lifeguards and assistant lifeguards. But since no equipments are yet to reach us, beach deployment of the passed out candidates cannot be executed by us under rules laid down by International Life Saving Federation, since it involves the safety of lifeguards as well as the drowning person. In the last paragraph also, last line also, we also request you to expedite the availability of beach lifeguard equipments for deploying lifeguards on beach through setting up the proposed
Anyway,
beach
the affidavit
management
says There
system.
are 98 lifeguards.
Only they have said, your lordships, but no actual record they have
No,
filed.
sorry.
In 2019, they have filed the 2012 document. Only my point is, life has to be saved. Nothing more than
You
that.
tell us that some life has not been saved. Give us some instance, then we can observe.
No
You're simply saying that. There must be some concrete instance. You say X and Y drowned because this was not provided. Bring us such
lordship.
instance.
Some time may be granted.
No. You don't start looking for it now. If there was really some instance, you should have brought it by now. You can't go start hunting for it.
Yes, sir. Yes, sir.
We'll pass the detail order. Disposed of. The petition is disposed.
Oh, blessed.
All right.
Only one submission exists. My para 4.5 at page 8 may be taken care. Oh, blessed.
We kill list item number 80.
May I please, Your Lordship? May I please? Lord, my lord, my file has been misplaced. If Your Lordship.
It's all right, sir. Whenever you find it, we'll revive it. Counsel,
yes.
the petitioner says the file has been misplaced. The petition is dismissed for non-prosecution with liberty to the petitioner to revive the matter of as and when the file is located.
We kill list past door matter item 61.
Dear Lord, an order of the Tahsildar is under challenge. First of all, the original order under challenge was under Annexer 7, but during the pendency of the present writ petition, a fresh proceeding was initiated, and it was ultimately a second order was passed under Annexer 8. Thereafter, I have to amend the writ petition and included the same. Now, the present petitioner is a beneficiary under a scheme called ERRP scheme. I have annexed that scheme. I have the certified copy of the English version. Under the scheme, the petitioner was allotted with a specific property. This allotment is under Annexer 2. I will come to it, and appropriate rent was also received. Now, some of the provisions of that scheme may kindly be referred to. Under this ERRP scheme, a particular patch of land is reserved and is handed over to some weaker sections of the people, along with some plantations. They will raise the plantations, and after 3 years of the plantation, the land which was allotted in their favor, that will be handed over to them. That means that it is permanently settled with the family, with the person concerned. And that is under clause 3. Kindly have a glance at.
Yes.
Clause 3 is there at page 2. I'm just placing 2-3 clauses. When the lands included in this program are fit for cultivation, those lands will be handed over to the families on individual ownership right. But in case of plantation program, in some cases, individual ownership right, and in
What
other
is the problem?
Pardon?
What is your problem?
Problem is the learned Tahsildar, at one point of time, a notification was issued by the government, including these properties under for the development of industrial area for the IDCO, for transfer of these properties. Thereafter, we raised objection. We filed our objection under annexure.
That particular area was in your name.
Yes, that plot
was granted.
Plot is very much under that.
Patta was granted to you.
Yes.
No.
He wants a direction now to initiate a case to alienate.
My lord, may I be permitted to submit two words, my lord?
No. Whenever government identifies the poorest people, they give a patta. I know.
Yes, my lord. What has happened in the meanwhile? Your lordship may kindly have a glance on my counter affidavit dated 26th August 2013. They had applied for lease under OGLS Act. 44 cases were instituted by 44 different applicants. All the cases have been dismissed by the Tahsildar. That is the order passed in miscase number 9 to 52 of 2013. That is at page 7 of my counter affidavit. My respectful submission is that their application is already dismissed under section 3 of the OGLS Act. They have invoked the power, and if at all they are agreed by this order, they have to approach the appellate authority. That because the Tahsildar has already declined to grant lease in their favor on whatever the ground may be.
Sub-collector.
So that is applicable. Section 3. This is in exercise of power under section 3 of the OGLS Act. So if they are aggrieved.
3B.
No.
3 capital B.
Your lordship.
It's a resumption miscase.
No, it is denial of.
Oh. An OGLS manual. Same.
Section 3 is reservation and settlement of government land, notwithstanding anything on this. So it is an application for settlement of government land under any particular scheme or whatever it may be. And that has been rejected. And Section 7, your Lordship may kindly have a glance, Section 7, this Section 3 order is applicable. If at all they are aggrieved by the order of the Tahsildar, wherein their prayer for allotment of the land under the OJSL Act has been rejected, and that order I have enclosed since 2013, they should have preferred the appeal by that time itself.
Lord.
Section 3 or Section 3B order, both are applicable under Section 7.
Yes.
What I beg to submit, I don't dispute the proposition of law that it is applicable one. But the proceeding was initiated during pendency of the writ petition, that too on the face of the earlier order passed by the same Tahsildar. There is no challenge to the earlier order passed by the same Tahsildar. Kindly have a glance at Annexure 7.
Challenge meaning who will challenge it?
Government should have gone in appeal or the appropriate authority. The law, same Tahsildar, what is the, I'll just place the findings.
No, right or wrongly, now there is a subsequent order which takes it away from you, right?
Yes, your Lordship may take care of that. I don't have this, but the same Tahsildar who found the possession.
That would be the ground in appeal. That would be the ground in appeal.
With this observation.
So you reserve your right, yeah, all right.
Because I am
counsel the petition.
Because during
withdraw this petition.
Subsistence of the earlier order, he has passed a subsequent one.
Liberty to challenge the order dated 13 June 2013, passed by the
Tahsildar Jatni in Miss case number 9 of 2013, 252 of 2013, 44 cases.
This case number 19 of 2013.
9 of
9, my lord, 9.
Only 9.
9 of 2013.
To 52 of 2013.
To 52 of 2013.
But you have written 19.
Page 47, the number is there.
My counter affidavit may kindly be seen. My counter affidavit, I have annexed that order.
9 to 2000.
Page 7 of
yes,
my
yes.
counter.
All right. In accordance with law, under the provisions of the OGLS Act. If such appeal is filed not later than 19 September 2022, accompanied by an application for condonation of delay, citing the pendency of the present petition as the reason for the delay, to be considered in accordance with law by the appellate authority, the court clarifies it has not expressed any view in the matter. It will be open to the petitioner to urge all the pleas raised in the present petition before the appellate authority in accordance with law. The petition is disposed of the above terms. Yeah, return it.
Supplementary list. Supplementary list. Case admission item number 1.
Your Lordship. Your Lordship, I'm appearing on behalf of Mr. Udit Ranjan Jena in item number 1. Your Lordship, in the meantime, we don't have any instructions.
All right. Counsel, the petitioner states he has no instructions. This was not.
Supplementary list item number 2.
May I please? Dear my lord, I have challenged the order passed under section 264 of the IT Act under Annexure 1 in expert manner without granting adequate opportunity. My lord, kindly have para 4 of page 20, Annexure 1, para 4, my lord. In response, Sri N.L. Agrawal FC and the authorized representative appeared on 14 February 2020. And relied on the petition, he also requested for adjournment, which are duly granted, and hearing was refixed on 5th March 2020. And in between, he submitted a petition on 24 February 20. The written submission was perused, a report was called on, and thereafter, on 5th March, when the authorized representative appeared before the authority, it was intimated that the London Commissioner is out of headquarters, and one more chance will be given, and next date will be intimated. But no date was granted, and thereafter the order in expert manner. And my written submission at page 90, my lord. At page 90, I have enclosed at the details at page 91, and those were in annexed here in the Annexure 4 series. All these documents were submitted before the London CIT. but without considering those documents, he disposed of ex parte without granting any date and any hearing, personal hearing to the petitioner, my lord.
What do you say?
Lordship, kindly have a glance to page 23. This is the observation of the Commissioner, my lord. Lordship, he has not participated neither before the assessing officer nor, my lord, the subsequent proceeding, nor, my lord, before the Commissioner, my lord, at that in the 264 petition hearing, my lord. So, my lord, in another paragraph, they are mentioned, my lord, whatever mail was made, the documents were not attached. It is found in page 22, my lord. Assessee furnished a written submission through mail in which it is stated that it had attached few documents, but except the written submission, nothing was attached.
No. I think the point he's making is about giving him a hearing. You fixed 5th March as the hearing, but did any hearing take place on 5th March?
Dear my lord, I didn't.
No, my lord, I have taken that.
I'm asking him, sir.
I'll obtain instruction on that, my lord. After 5th, my lord, before 5th, the date was 5th. It is found, my lord, on 5th. It was adjourned to 5th.
No. What happened on 5th?
My lord, I'll.
Counsel for the notice, he accepts notice. Counsel for the department seeks time for instructions on whether any hearing was actually held by the assessing officer on 5th March or any subsequent date, and whether the present petitioner was heard on such date prior to passing of the impugned order under section 264 of the Income Tax Act 1961. That is a request list on. October.
I prefer no coercive action in between, my lord. Sir.
From 2020, for the first time, it's coming up, sir.
No, my lord,
nothing has happened
in between,
so far.
they have a pressing heart for
Suddenly, because we listed it on our own, it has come today.
No, I'm going to file the memo.
No, nothing. Yes.
Supplementary list item number 3.
May I please, Lordship? Lordship, I am challenging the order under Annexure 3, Lordship. That is page number 15, Lordship. For non-consideration of my application for compassionate appointment under the Rehabilitation Assistance Rules, Lordship.
What are the grounds for that? What are the grounds?
Lordship, they have
memo. Page 15. Notice, Mr. Monty accepts notice. Reply be filed within 8 weeks, rejoined up for the next date. List on.
Let's
17th October.
let's a batch of these matters because the rules that are impugned here that have been challenged in a batch of matters, and my lords has posted it for tomorrow.
It's okay. We'll adjourn this to tomorrow.
Yes.
That day.
Let it come
We'll
tomorrow.
those matters will adjourn to 17th.
That's
all right.
Oh, please.
Number. Give the number.
Well, I'll give.
No, it'll come up tomorrow. We'll adjourn it. All right.
Supplementary list item number 4.
May it please, my lords. My lords, in this case, my lords, a reassessment order was passed in violation of GK and drive shafts, my lords. Thereafter, my lords, we have filed an appeal. Now that appeal, my lords, was filed on 25th April 2016. Thereafter, hearings have been made. Written submissions, my lords, have been filed. The proceedings are completed since 6th of March 2021. The appellate order is not being passed, and on the other hand, my lords, I am being pressed for recovery, my lords. My lords, the department's own circular states that after conclusion of hearing, my lords,
your impugned letters are 8th March and 21st April.
Yes, of 2022.
I know. We are 3 months away. We are in July, end July, sir. By now, they should have attached your account or something.
Let's.
If they are really pressing,
my lords, during the course of the assessment, my lords, even before passing of an assessment order, they had attached my accounts. That still is there.
No, that's right.
That still is there, my lords. To under 281B, provisional attachment, that still continues.
All right.
My humble submission, my lords, is that in when my stay petition is pending, my lords, I am not an assessee in default. That is number one, my lords, and therefore my
what are they seeking to do? That's not clear. What do the impugned letters say?
For recovery, my lords.
That's it. Simply asking you to pay up, right?
Yes, my lords. But
so the last 3 months, nothing's happened. The last of those letters is 21st April. Nothing's happened since then.
My lords, only thing, my lords, is that the appeal, my lords, is not being disposed of.
So we can pass an order saying that appeal be disposed of expeditiously.
By December 2022.
Sorry?
By December 2022.
December?
December. The
All right.
faceless assessment.
My lords, only December. My lords, we'll just have a look at this circular. After hearing, my lords, the department's own circular says 15 days within which they have to pass an appellate order. This is the circular, my lords.
Since when is the appeal pending?
Appeal pending from which day?
From 25/4/2016, my lords.
Oh, I see.
And my lords, we have filed all our written submissions.
According to the petitioner, the appeal filed before the Commissioner of Income Tax Appeals against the assessment order for the assessment year
9/10,
9/10 has been pending before the CIT bracket A since 25th April 2016. No, is it 25th April?
Yes, appeal was filed on 25th April. My lords.
It is stated that even a stay application filed along with that appeal has still not been taken up for hearing. So in other words, the appeal along with stay applications are still pending for over 6 years now. Paragraph. In the circumstances, the petitioner has approached this court because of two impugned letters dated 8 March 22 and 21st April 2022 issued by the PCIT-1 Bhubaneswar.
It's actually the tax
asking him to pay the arrears of outstanding demand.
That is actually the tax recovery officer.
The tax recovery officer asking the petitioner to pay the outstanding demand. Stop. Mr. Chamankar, learned senior standing counsel of the department appearing on advance notice, is unable to deny the above facts. He states that if a time-bound direction is issued for disposal of the appeal and pending application for stay, it will be complied with. Paragraph. Accordingly, it is directed that the pending appeal and application filed by the petitioner before the CIT bracket A for the aforementioned AY be taken up for hearing at the earliest and in any event be disposed of not later than November 2nd, 2022. Till then, no further coercive action can be taken against the petitioner. No further directions are called for the petition's disposal.
I'm grateful. Plus, second also relating to assessment year 10/11.
All right.
The next
same order 10/11. All right.
Great.
Supplementary list for orders item number 5.
None appears dismissed. No.
Supplementary list item number 6.
Yes, my lord. May I plead, my lord. In this case, my lord, petitioner challenged, my lord, the virus of the notifications under Annex 5, my lord. So, similar order, my lord. See, similar case is posted before your honor on 16/11/2022 with the WPC number 8960 of 2020, my lord.
All right. Notice has gone in this?
Yes, my lord. My lord, in this case, not gone.
Notice, he accepts notice.
As a copy may be served.
My lord, there's school.
He accepts notice for opposite party number. This is all higher education department.
Well, sorry.
We now issued to opposite party number 3, returnable on the next date. List on
List on my lord, 16/11/2022.
Along with writ petition civil number
8960/2020.
8960/2020.
Yes, ma'am.
All right.
Obvious.
Item number 7.
Madam, I shall remove the defect by Monday.
All right. Defects be removed within a week. List thereafter.
Supplementary item 8.
Here the petitioner is the Deputy General Manager of Jagannath Steel Power Limited. He challenges the Annexure 1, the demand notice by the opposite party number 3 with regards to engine hire charges and demurrage charges on similar identical matter. Lordship may fix to 24/8/2022 and same circular Annexure 3/4 and challenge that
All right. List along with
32208 of 2021.
3008.
No, 32208.
2208
or 2021.
List along with that on
24/8/2022.
or 24/8/22.
On that case, Lordship granted interim order. Stay the demand notice, Lordship. This is the order, copy, Lordship.
All right. Notice is till the next day there shall be stay of the demand notice. All right. Right.
Supplementary item 9.
Well, item 9, a public road of my village has been enclosed by the office number 6. I have repented to the collector that
All right. The petitioner's representation.
Repentation by Annexure 1.
Now, what is that to show this representation?
It is in English in page 42. All are ODI, but I have annexed to the page 42.
No. What is that to show? This has been delivered. No postal receipt, nothing, sir. You make a fresh representation, permitting the petitioner to make a fresh representation to the authorities, and after following up with some representation to seek appropriate remedies in accordance with law, the petition is disposed of.
After hearing the opposite party number 6, the alleged encroacher.
No, let him first make a representation.
Supplementary item number 10.
My lord, 1 week time to remove the defect, my lord.
Defects be removed within a week. List thereafter.
Supplementary list item 11. Item number 11.
None appears to be no.
Supplementary list item number 12.
My lord, your lordship directed last occasion annexure 16.
Not remove the defect with the Monty.
Page 50.
That's nothing much. This is regularization.
My lord, lordship's directed annexure 16, page 51. If a petitioner is agreed by decision of the appointing authority, then it is open to him to approach again.
All right. Notice, Mr. Mudali accepts notice. Reply within 8 weeks to join up with the next day.
My lord.
27th October.
My lord.
Supplementary list item 13.
My lord, I am appearing on behalf of Advocate P.K. Rath. Matter may be taken up after a week, my lord.
What? Okay, defects be removed. List thereafter.
Yes, my lord. In the meantime, we'll take
Yes.
steps to remove
All
the
right.
defect.
Supplementary list item number 14.
Item 14 minutes, I play 7 days to remove the defects.
All right. Defects be removed within a week. List thereafter.
Item number 15.
May I please, Lordship? First, a similar type of case.
In fact, we have removed the defect.
Pardon, Lordship.
No. Same. You say notice.
Yes, Lordship. That is case number 3.
Okay, not given to them.
Same kind of relief. Notice Mr. Mudali accepts notice.
No.
Which is that date?
17th October.
Reply be filed within 8 weeks to join up for the next date. 17th October.
Supplementary list items.
Pardon, Lordship. Lordship, in item number 3, Lordship passed order for it will be put up on tomorrow along with that batch cases.
No.
Yes, Lordship.
We've given a date in the item 2. The other batch
Item
will
number
come.
3, Lordship. Item number 3.
That's some other matter. Yeah. 17th October.
Supplementary list item number 16.
May I please, Your Lordship? My Lord, it's a public interest litigation. My Lord, here a fire station is functioning at village Baldia. And Your Lordship have a glance the page. The land alienation process started in the year 2016. Now, my Lord, I have given the photograph. Your Lordship have a glance. The fire station is functioning. Now, my Lord, they are going to shift it to another place, to an interior place. That is why, my Lord, the representation at Annex 2 to the collector.
Fire, you don't have to push, I mean, pull or push the fire, the vehicle.
They have already made a representation to the collector at Annex.
For what, sir? How does it hurt you? How does the shifting the fire station inside hurt you?
No, my Lord, for that purpose, my Lord, the land allotment process is over. Your Lordship have a glance. The order sheet, Your Lordship, for a moment, turn to page 35. The land alienation process is over. It is functioning. I have given the photograph. Now, my Lord, they are at the instance of a particular political leader, my Lord, they are going to take.
Lord, how does it affect you, sir? That
because, my Lord, we the locality, my Lord, will be affected.
How?
Locality, the local people, my Lord, I have given because, my Lord,
how you are just tell already.
My Lord, in order to avail the service, my Lord, we are depending on in order to avail the service.
Somewhere centrally it should be located so that everybody is accessible to everybody.
It is a central located. That is our case, my Lord. It is accessible, centrally located. Now, my Lord, they are going to take it to another place.
Fire brigade runs some petrol and you have a vehicle. So it can go to any place nearby. Don't worry.
No, they are going to shift it to another place, my Lord. My Lord, the land alienation process is over. Your Lordship, you have a glance, page 45. In view of the above, the miscase number 1 of 16 record along with alienation case are submitted to Sub-Collector Baripadar for alienation in favor of the Home Department. So that
have you approached the collector?
Yes, my Lord. Annex 10 is the.
So what is the outcome?
Annex 10 is our.
Did he pass any order?
No, my Lord. No order has been passed. That is, my Lord, our case, my Lord. That is in the year 2018, since 2018.
It's all right. You see, the question of correctness of the decision of the opposite parties to shift a fire station from village Baldiha to Sapan Pichwa of Rangamatiya Gram Panchayat is challenged in the present petition as a PIL. Paragraph, having heard learned counsel for the petitioner, the court is not persuaded that any serious prejudice is being caused to the petitioner as on account of the shifting of the fire station. The court is therefore not inclined to grant the relief prayed for. The petition is dismissed.
But at least Annex 10 may be considered by the collector, my Lord, since it is 2018, it is pending.
You give a fresh recommendation, he will consider.
Yes,
then you withdraw this.
Yes, I'll file.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation to the authorities concerned. And after following up on such representation to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberties paid for in the above terms.
Okay.
Supplementary list item 17.
So may I please, my lords? So this is a case, my lords. In spite of, my lords, the ratio laid down by the Honorable Apex Court in lovely.
There are defects and all that.
Defect, my lords. Sir, I will remove maybe trivial, my lords. If your lordship permit me, I have given a copy of your lordship's order, my lords. In similar matter, my lords, this is addition of 68, that is how led to demand, my lords, appeal pending. Pending appeal, my lords, now I have been directed to pay, my lords, 28% amount, my lords. And I have, on the other day, I have given a copy of the Honorable Apex Court judgment as well as Delhi High Court judgment. Your lordship have kept the matter.
That's right. Only today we got, we were told that this LG Electronics.
Yes, your lordship called the matter.
This morning also we disposed of similar matter.
Yes, this matter your lordship wanted to give response from my friend. They also wanted to give response.
Yesterday, your lordship passed the order.
Correct.
particularly where your lordship finds prima facie case,
correct.
whether the circular will apply or my lord's.
He's not bound by that circular to only
Exactly.
have.
That is what all apex court has said.
Correct.
I think they have now they are going to file counter, and your lordship have kept this matter to September, my lords.
But in another matter this morning, we passed it.
That was not brought to your lordship's notice, my lords. Probably they have not. And this matter, your lordship have kept it to September. And my friend
Actually,
wanted
today we disposed of matters in terms of this LG Electronics. We have said that they have to take a fresh decision, keeping this order in view. We've set aside that order and sent it back for a fresh order.
Millers. I think if they give response, Millers, my lords, as my lords,
notice, Mr. Chimanka accepts notice.
My lords.
Returnable 19 September till the next date, no coercive steps we take. All right.
Obliged.
Extra copy may kindly given.
My lord.
Supplementary list item number 18.
From have been called in another court. Can it be taken up tomorrow?
At the request of Mr. Mudali, list on tomorrow.
Copy not served. Yes, we have. No, here we are the petitioner. Petitioner not served copy to the copy.
12th October.
File the counter affidavit.
Tomorrow you will not see.
12th October.
Supplementary list item number 19.
Item number 19, your lordship. This is that similar matter that is covered under your lordship's judgment, right? WPC number. Yes, your lordship.
Give us the order copy or judgment. Where is it? You sent it here. You give us a number and date of the
Yes,
order.
your lordship. That is your lordship. WPC number 17505 of
They are filing the counter. They are indicating that the order which was passed by my lord, that is now the subject matter challenge for the Honorable Apex Court.
So yesterday also same order was passed.
Yes, your lordship.
Page 8, just above paragraph 2.
Correct.
Diary number 22626.
Correct. The order passed by this court on 18th April 2022 in 29 Petition Civil 26692 of 2011 has been challenged by the opposite party state in SLP Civil Diary number 22626 of 2022. List this case on, which is the date?
18th October.
18th October.
Obliged, your lordship.
Supreme Court, yeah.
Supplementary list item number 20. May I please? No, this is a PAI.
Food security.
Yes, my lord. In terms of the last order dated 19th May.
You have to file an affidavit.
Yes. On 22nd June 2022.
You've seen this affidavit, Mr. Jena?
No. I have not received any copy.
No. The affidavit dated 22nd June 2022
I'm
of the
extremely
state
sorry,
be
but
served on Mr. Jena today.
Just now
itself.
I'm giving. Just
Today itself.
Yes, today itself.
List on.
Why the government side wait till the court?
No. In very.
It is your duty to give him.
In very few cases, this is happening.
In very few exceptional cases you give.
I'm very extremely sorry, my lord.
Everywhere I'm saying same thing in every court.
13th October.
No. In this case, how
13th October.
Yes, my lord. 13th October. Ticket please.
21.
Supplementary list item number 21.
Yes, government will file counter, my lord.
What is it, sir? No counter. 21. Last opportunity to file counter. This 3 and 5. Who are 3 and 5? AD is not back. AD is not back from 4. Anyway, it's all confirmed. All right. Counter affidavit will be filed as a last opportunity within 8 weeks. Adjourned to the next week. Is there any interim order?
In the connected matter, counter has been filed. And I have also filed the rejoinder, but that has not been taken.
List on. Second November.
Supplementary list item number 22.
Please, ma'am.
Beg pardon to mention also, in the connected matter, counter has been filed and I have filed the rejoinder also.
It's all right. One matter.
Okay.
Item 22.
Please, my lord, on behalf of Mr. Jaina, my lord, may grant us 2 weeks time more to file rejoinder, my lord.
This was, my lord, beg pardon, my lord. I am for the opposite party number 4. Your lordships, if the matter is adjourned for filing of rejoinder, my lord, that is different.
Well, last chance will
But
be
what
given.
I will beg to place before my lord, that this relates to promotion in the post of Sirastadar in the district court Khorda at Bhubaneswar, which is lying vacant since December 2001. And there is no stay order. My lord.
Outcome.
My lord, there is no stay order. It's subject to outcome, your lord.
You have already said that.
No, my lord, that is not there specifically.
9th September, sir. Just show them the order. 9th September order.
Sorry, my lord.
No, it's there.
Must
Just
have
see it.
escaped my note.
Just see it.
Otherwise, I would not have bothered you, lord.
No. Just see it. See it. In service matters, this is a standard order.
Yes, my lord. My lord. Obliged, my lord. That's sorry, sorry. My lord.
All right.
Yes, sort.
1st November.
Supplementary list item 23.
My lord, in this matter, the opposite NHI not filing counter. My lord, can you see the last date?
All right. Last
This short for 4 weeks time. Now the 4 months have been elapsed, not filed.
Mr. Das.
Yes, my lord. I'll file it by Monday, man. It is ready, my
Mr.
lord.
Das assures the court that reply of the NHI will be filed on or before
2nd November.
First 2022. Less than 30th August.
Supplementary list for hearing item 24.
May it please your lordship. My lord, item 24. Your lordship, my lord, is a very small question involved.
Yes.
The question is, executive instruction passed by a secretary cannot override the law. Your lordship, may kindly see the order dated 13/4/2021. My lord, the order dated 13/4/2021. The lordship has made it absolutely clear. I am reading paragraph 3 of the order. My lordship, I may be permitted to read, my lord.
Yes.
My lord, 13/4/2021, paragraph 3 says, this is particularly with reference to question of law raised by the petitioner that by executive instruction dated 24th June 2015, the commissioner cum secretary to government, school and mass education department could not have limited the appointment on compassionate ground to group D posts, thereby altering the position under Orissa Civil Services Rehabilitation Assistance Rules, which provides for such appointment against both Group C and Group D posts.
My lord, in this case, my predicament is, the brief is not with me, but even then, if your lordship will see the rule 7, that nowhere bestows any absolute right on the applicant to be considered or to be given employment under group class 3 post.
That is not absolutely
the other way around, sir. The question is, by notification, can you say
that cannot be? But
let it
my humble submission is the element of discretion is there.
No, that is a separate thing, sir. Your threshold, you're eliminating this possibility by notification. You're saying it will not be considered for Group C at all.
Because may I?
You remove this restriction, then consider him, then say, no, I don't think he's fit. That's different.
Yes, your lordship.
Where is your affidavit?
My lord, the counter has been filed and rejoinder has also been filed, but the brief is not with me. And the rejoinder copy has also not been served upon me, my lord.
All right, copy
that is already served, my lord. And this is squarely covered by recent judgment of Honorable Supreme Court, Malayananda Sethi versus State of what your lordship has said.
That is on a different context, my lord.
No, my lord, only on this context.